Well, good afternoon, everybody. Thank you, and good morning, good afternoon, and good evening from wherever you may be joining today. So this is the second day of this consultation webinar, and yesterday we had several interesting presentations that touched upon different variables that may influence the choice of the legal structure. So yesterday we had held the first day of this consultation webinar, and we had a number of interesting presentations addressing how the decision regarding the possible legal structure and organizational models in agri-food chains may be developed and how it can be done through contractual arrangements. We also heard about a number of different variables that may influence the choice of the legal structure. So today, during this fourth session of the consultation webinar on the legal structure of agricultural enterprises project, jointly organized by UNIDROIT, FAO, and IFAD, we will be looking at the corporate structures for the organization of farmers and agricultural enterprises. During this session, we will be covering how producer organizations may play different roles and their potential, and we will discuss about their potential and how it varies depending on whether they are informal groups, whether they organize themselves as associations, or other forms of civil society organizations, cooperatives, or commercial companies. During this session, the discussion will also focus on the corporate legal structure that may be established for investment in agricultural activities and how these investments may be channeled internally and externally among the different entities that collaborate within the global value chain, for example, and how these different entities may use different criteria such as member participation, access to capital, decision-making procedures, the allocation of risks, and also how they organize the responsibilities within the actors that participate in the legal structure and how they organize the profit sharing. We have several interesting speakers in this panel, and I will introduce each one as they speak. So I'm happy to pass the floor to our first speaker, Virgilio de Lourdes. He is Dean at the College of Law at De La Salle University, Manila in Philippines. He was the Secretary of Agrarian Reform of the Philippines and Director of the Land Bank of the Philippines during the years from 2010 to 2016. Virgilio will be speaking to us today about the juridical vehicles for community-based agricultural enterprises. It is a pleasure to have Virgilio with us today, and since he also contributed with UNIDROIT, FAO, and IFAD also in previous projects as the project on agricultural land investment contracts. So thank you very much, Virgilio, and I pass over the floor to you. Thank you.
Thank you very much for inviting me. It's an honor to be here. And once again, it's great to see our friends at UNIDROIT and the others who were with us in the previous projects. If I can share screen. I think my sharing is still disabled. Can you hear me well?
Yes, Virgilio, we can hear you well. Can you share your screen, please?
It's still disabled.
Now I think you can share it, Virgilio. Thank you.
Oops, it's still disabled.
Okay, Gabriela.
Host disabled, participant screen sharing. Okay, let me try. It still won't move. It still won't allow me.
We will share it for you, Virgilio.
Sure. Okay, that's good. Let me put it up on my end then. Okay. All right. Is it showing now? All right, thank you. Okay, so good evening. Um, the contribution I hope to make today is a product of practicing law in the Philippines, but at the same time trying to be a policymaker and a regulator of agricultural organizations in the Philippines for 6 years. The other experience I've had is, as I said in my little blurb, was running or being a director of a land bank. The Land Bank of the Philippines is a government bank whose main focus is financing fisheries and the agricultural sector. So slide 2, please. So let me try to situate my sharing on the two legal guides which the UNIDROIT, FAO, and IFAD have developed. And the contract farming legal guide, which was finished in 2015, talks about two parties, the contractor and the producer. The contractor being the organization that bought the produce, and the producer meaning the community-based enterprises, smallholders, or family farms. And the legal guide on contract farming talked about two parties, the individuals, two parties who may compose the producers, the individuals who may be natural persons or partnerships, which may be formal or informal, or corporate structures set up by the individuals. Or second will be producer organizations, which could either be informal arrangements or non-profit entities or cooperatives. However, the 2015 legal guide on contract farming did not dive too deep into the kind of legal entities that may be set up by the producer. The agricultural land investments contracts on the legal guide, which came out or in 2020, which we hope will be printed soon, talks about two parties, the investor and the grantor. And the grantor were the legal tenure rights holders and could take several forms. Either the government, which in cases where the government owned the land, or a local community or private landowners who could be individuals, families, it could be indigenous peoples or other juridical entities. Now, briefly, when I was asked by Priscilla to wrap my brain about what the legal guide on juridical entities of smallholder farmers could be, I went back to the two guides, third slide please, and I said, what is this? Who is this guide for? And if you see here the markings in yellow, these are essentially for people who are the producers, not the contractor. This is for the grantor, not the investor. And the producers could be corporate structures. It could be producer organizations. It could be non-profit entities. Yesterday, we were talking about informal arrangements where we wrap the relationship between contractor and producer in terms of contracts. Or this could be cooperatives, or this could be IP communities, because in some countries, there is an allowance for the formation of juridical entities by indigenous peoples communities like what we have in the Philippines. And in the case of agricultural land investment contracts, this would be about the grantor, and this would be the legal entity for the local community, private landowners. So I imagine that the next project on legal entities will not cover governments at all levels. It will not cover the parties in the case of natural persons. So that the yellow highlighted portions here are the gaps that this third project will fill. So fourth slide, please. So let me focus on juridical entities, and I'm not going to go into a long discussion on why we even think of juridical entities for producers and grantors. But at this point, it will be sufficient to just tackle basically 3 points. One is that we set up juridical entities or legal entities because of coordination issues. Now, in the past, yesterday, there were a lot of discussions on coordination issues.
But I think the basic message is that these are coordination issues which are long-term, which do not go on a per contract or on a per sale or per purchase agreement. But as you all know, in the case of juridical entities, we've always characterized it as a bundle of contracts. And this bundle of contracts seeks to address these 3 points: coordination issues, legal personality, and the legal personality primarily being of the limited liability, and trying to determine the identity and who are the representatives of the juridical entity. And third would be access to funds. Now, later on, I think we're going to be hearing a lot from our colleagues on credit and agricultural production. So this would take the form of loans, forward contracts, or entities or equities. So after this, now that we've established that, the next question I began to ask myself is, if we were to do a legal guide on the choice of legal entity or juridical entity for smallholders, family farmers, or community-based enterprises, what would these questions be? So I will not seek and try to answer these questions, but instead what I would do is come up with the questions that we might be raising. And another background is the legal guide on contract farming, a 2015 edition of the UNIDROIT IFAD, was a subject of an administrative order that we issued in 2015, 2016. And we took inspiration from the legal guide done by these 3 Rome-based agencies as the framework for the establishment of smallholders and producers in the Philippines. And so if you look at the footnotes of those administrative orders, you're going to see UNIDROIT, IFAD, and the FAO. So what are the points to consider in choosing the legal entity? Because like I said, in slide 3, and we're now on slide 5, we are doing this legal guide primarily for the producers and the smallholders, community-based enterprises, and farmers. So if we can shift to slide 6, let me give you a little bit of background on this particular diagram. Slide 6, please. Next slide. That's it. Okay, thank you. This particular diagram I borrowed from Pestov and Dufourny, and they were trying to situate the third sector, what they call the social enterprise. So the basic framework that you see here is the typology of where organizations might be. And I adapted this so that you see the middle circle, which is the third sector. And the basic message I have here is the choice of a legal entity is actually in a continuum, and that means it's a timing issue. So that if you look at the left side, you could very well have individual farmers as a community coming out in the informal sector, non-profit, and private. But as they engage in more production activity, they will slowly move to the right side, where you see the community-based enterprises and the social enterprises, which are still private, which have become now for-profit, and may now become informal. So that I think one of the messages I need to send is the choice of a legal entity of smallholders or community-based enterprises or family farms is really in a continuum, and there isn't a good time. It doesn't mean that if we're going to go into production, we should be going immediately to the private, for-profit, formal. But it could very well be that the choice of legal entity moves across a continuum. It could even become from a voluntary non-profit organization. It could even be a situation where when you see the intersection between non-profit, public, private, you can have state-owned enterprises infusing equity into social enterprises or community-based enterprises. So I think the first message is, what is the timing of setting up the particular juridical entity? And the basic message I have is, there need not be one. You could actually flow across a continuum. Next slide, please, 7. So the other thing that we may want to consider is that at different points in the value chain, it will actually may require different juridical entities. And as you will see in slide 8, which is the value chain of sugarcane production in the Philippines, developed by Professor Mendoza and Mr. Sandoval in the Philippines. And the reason why I chose sugar is because most of my clients before I joined government were sugarcane farmers and organizations. You could have a situation where, if you recall the earlier triangle, you could be moving for a non-profit where you put together the purchasing of inputs, and it could actually be a cooperative doing the purchasing of inputs like fertilizers or cane points. And as you move to the continuum going to the right, you could have smaller groups of farmers coming up with for-profit or formal organizations. So I think the second message I have is the choice of juridical entity depends on in what part of the value chain you can come up with. And I've seen many situations where people tried to collapse the entire value chain into one legal entity when the different parts of the value chain would require different kinds of legal entities because you would have different considerations. So you could have a no profit in terms of inputs, but to drive the purchasing price of fertilizer down. And you could have a for-profit coming out with in a marketing or in a semi-processing, but this will actually involve the same smallholder. So that one smallholder could be a member of a cooperative in the inputs and could be part of a smaller juridical entity in terms of selling or pre-processing or semi-processing the particular product. So the choice is not shouldn't be static, and we shouldn't be forcing everyone into the same legal entity. So it could actually change. Then we go to slide 9. Yesterday, there was a lot of discussion about contracts. So you could have a contract between a supplier of inputs, a group of farmers, and a group of farmers with a forward contract on the production. So here, I imagine the guy to be talking about when do you do transaction-based contracts, or when do you establish a juridical entity? Of course, establishing a juridical entity has more stability, but it doesn't mean that not having a juridical entity is necessarily bad. And this is something that is, I think, a vacuum in terms of discussing this or elucidating these considerations to smallholders and producers. Slide 10 is a variation of what I said earlier in the value chain. Are we up for profit or are we up for cooperation? And the example I gave earlier is in terms of fertilizer. If I want input and be able to have coordination costs lower by buying a truckload of fertilizer, I could just be recovering cost. But the moment I put the fertilizer in the sugarcane farm and I decide to jointly sell it, I could be deriving a profit at that point. So you would have a situation where you might have a cooperative in the inputs and a small corporation or a limited liability organization made up of a small group of farmers in pre-processing. So again, these are considerations that need to be looked at in the choice. Slide 11 is something very, very important, and this is a major issue for us in my experience, the problem of inadequate contribution and rewards. And we all talk about the freeloader problem. And the freeloader problem in any organization is a major issue and a major cause of the breakup of a lot of juridical entities established by smallholders or by farmers organizations. Many times, as a government official, the idea is we want to be able to organize farmers in a big way in a short time. So the more farmers we are able to put into a juridical entity, the better. The problem there is that how do you balance the issue of contribution and reward? So that's why the freeloader problem. That's slide 11. Slide 12 is resource mobilization. There's always a big debate about, and this is closely linked to the issue of management. Are we going to accept equity from people who are not smallholders, who are not community-based, who are not family farmers? How do we scale up, or do we just depend on loans from government? So resource mobilization is going to be an issue which needs to be discussed at the beginning of the formation of the legal entity. Slide 13, there is always, in many countries, a preferential treatment arising from government incentives. So even in the Philippines, we would have preferential treatment in terms of getting loans if you're a cooperative. There is a special window in the Land Bank of the Philippines that helps cooperatives come up with their business plans. So between a cooperative and a corporation, the rules are such that it is skewed in favor of cooperatives. So it's not a simple choice of what is more convenient for us, for the farmers or the smallholders, but also what kind of incentives you can derive because of the legal entity that you create. And slide 14 is very much linked to resource. Management control will always be an issue. I know that the big cooperatives with professional managers, but the issue of delinking ownership and control, or the merger of control and ownership, is going to be an issue all the time. And I think the legal guide will need to look at the considerations that smallholders or family farmers will need to consider. Now, again, my first two messages is that the legal entity choice is in a continuum, and it depends on what part of the value chain the juridical entity is supposed to address. So there is no one size fits all. Slide 15. Many farmers organizations begin as an advocacy group. So in the case of the Philippines, many farmers organizations begin as an advocacy group to be able to gain control of the land, which later on transforms itself to a larger political agenda of coming up with land for the landless. But at some point, it becomes a business proposition. How do we manage the transition? In fact, one big issue we've had in control in many farmers organizations is the mass leader who can stand on top of a flatbed truck to mobilize political support may not necessarily be the best manager you can find when your primary consideration is to make a profit for the legal entity. And slide 16 is, do you pay tax, or would you rather have a mandatory expenditure? And this is very common in the case of are you going to be a cooperative or a corporation? So a corporation would have a tax, but the cooperative may be tax-free up to a certain level in the Philippines, but you have mandatory expenditures or compulsory corporate social responsibility. Slide 17 is an issue on principal agent. And this is very material to the agricultural land investment contracts. Sorry about the wrong spelling there. The principal agent issues, and this is very much linked to the management and the ownership control. Now, what are the options that we are going to be looking at in today's forum? Well, everyone is familiar with cooperatives. We are looking at the corporations, but of course, they can be for-profit or non-profit. Non-profit organizations normally begin, advocacy groups begin as non-profit and then later on transform themselves to for-profit. There are special purpose entities in different parts of the world. You have community interest corporations, you have benefit corporations, low profit limited liability, social purpose corporations. They go by different names. But the bottom line is these are juridical entities established for some social purpose, and this would have tax implications. And I think one of our colleagues is going to be discussing limited liability organizations for small and medium enterprises. This is something that we recently had in the Philippines also. So I'm on slide 18 now. That talks about small groups of people who can come together. In fact, one retort that we've had in discussions in legal entities in the Philippines is that when you are farmers, you need to be at least 15 because you need to set up a cooperative. That's the minimum number. Whereas if you are wealthy or you have some wealth, you can come up with a single person corporation, which gives you limited liability. Recently, a new law was passed that allows limited liability organizations in the Philippines. Of course, another option are registration of IP communities, and I referred to this earlier. And the last are joint venture agreements, which could be on a per cycle or on a per cropping period joint venture agreement between a group of farmers and contractors. So this would be my thoughts on what might the legal guide cover, because in my mind it's very clear that the target are producers and grantors of tenure rights. So that if you put together the two guides, the legal guide on contract farming and the legal guide, the agricultural land investment contracts, and the legal guide on the choice of legal entity for the agriculture producer, we would have gone full cycle in agriculture. We have the contract farming, we have the land investments, agricultural land investments, and the third guide, which is what we're discussing in these 2 days, will focus on the parties to the contract, because this big issue is the one that was not distilled too well by choice in the first two guides, and it's very good that we're now working on this third guide. So I think I will end there, and I hope I was able to meet at 10 minutes of Priscilla. Thank you very much.
Thank you, Virgilio. That was a very interesting presentation and very helpful for us to think about the next steps of this project and the scope of this project. So we have several questions to be thinking also debating during the open discussion that we'll have in a couple of minutes. So we can go ahead. I would like to invite the second panelist for this session, Professor Hagen Henry. Hagen Henry studied law and qualified as a judge in Germany in 1981. He's postgraduate studies in development issues and development law in Geneva and Paris. Professor Hagen is also qualified in law from the University of Helsinki, where he works today. He will be speaking to us about agriculture cooperatives and global agri-food chains, and he will be sharing a legal perspective in that sense. We're very happy to have Hagen with us because he participated also in that colloquium that was held in 2011 when we first started debating about the possible topics that we would address in the private law and agricultural development projects within the partnership with FAO and IFAD. So thank you very much, Professor Hagen Henry, you have the floor.
Thank you, Priscilla. I have to thank for the invitation. I'm really grateful for that, and I'm indeed honored to share some ideas on the subject which you just mentioned. Among the various types of cooperatives, agricultural cooperatives stand out by number and relative success. And our colleague, my friend Georg Miribon, he can probably enlighten us on what agricultural cooperatives are. Like all types of enterprises, they integrate ever more into global value chains, not only operationally, but also organizationally, and that is my focus today here. In some instances, they form agri-food chains of their own. In most cases, however, agricultural cooperatives integrate into agri-food chains that are composed in the majority of other types of enterprises than cooperatives, and those are also the leaders in the value chain. The objective of this very brief presentation is to discuss from a legal organizational point of view, the consequences of the integration of agricultural cooperatives into this latter type of value chain in terms of the cooperative principles as recognized by public international law, in terms of farming structure, and in terms of sustainable development. From a legal organizational point of view, these consequences may be assessed by relating the structure of value chains to the structural specifics of cooperatives as compared to other types of enterprises. These value chains consist of heterogeneously structured participants. And some of them develop even their own purpose, their own objective, and tend to sort of organize instead of just being linked to each other, linking the participant parties by contract. The organizational coordination in these value chains is difficult, as in most, if not all, the value chains involving agricultural cooperatives, the two archetype enterprise forms meet, the capital-centered one and the person-centered one, and their forms differ because of their different purposes and objectives. Whereas capital-centered enterprises, example stock companies, are investor-driven and supposed to produce shareholder value, the person-centered one, example cooperatives, are member needs-driven and supposed to produce member value. According to the definition of cooperatives as recognized by public international law, this member value consists of economic, social, and cultural components. And the definition lays also the cornerstone for the form of cooperatives by stating that the cooperative enterprise be controlled democratically. Democratic control, participation by the members, is to ensure that the three component parts of the objective of cooperatives do not drift apart, and this works also as a regenerator of social justice, the centerpiece, the central aspect of sustainable development. On this point, the definition of cooperatives is reinforced by three cooperative principles, namely democratic member control, autonomy and independence, and cooperation among cooperatives. Now, while the relationship of the first two principles with democratic control is obvious, the significance of the principle of cooperation among cooperatives is widely ignored. Beyond cooperating for economic reasons through secondary cooperative organizations called unions, and for social political reasons through secondary and or tertiary cooperative organizations called federations, confederations, cooperation among cooperatives is to ensure democratic participation. And the membership in unions and federations must therefore also be seen as a structural element of primary cooperatives. In situations of power imbalances, and especially economic power imbalances in capital-centered enterprises, the leaders, it is unlikely that coordination measures will lead to maintaining the democratic participation of the farmer members of the agricultural cooperatives. And if you look at the protests of the farmers in India at the beginning of the year, I think you might find an explanation in through what I'm saying. While this argument is not questioned, the possible negative impact on social justice is questioned. The claim is that a number of developments or measures compensate for the negative impact and or make the difference between enterprise forms even irrelevant. And I'm just pointing to the corporate social responsibility, which has been mentioned, which is extending to also cover societal issues, and it's juridicizing. There are more and more countries implementing social, sometimes social and solidarity economy promotional measures, likewise on social enterprises, which all have the aim of ensuring greater social justice. The new paradigm to sort of cover all that seems to be stakeholder value superposing or replacing somehow the shareholder value and member value, and making the difference between the enterprise types irrelevant. Now, the reduction of the diversity of organizational enterprise types or forms, which is implicit in this argumentation, is not only impracticable because people have different and diverse needs and preferences, it also defeats the aim pursued through these measures or developments, such as, for example, greater economic security. Greater economic security in the sense of resilience requires a diversity, as does, by the way, sustainable development. The difficulties agricultural cooperatives face when integrating into value chains in terms of democratic participation of their members are exacerbated by cooperatives and cooperative law, which is to translate the cooperative principles into legal rules, not having been particularly successful in addressing what has become known as the cooperative-specific control risk, meaning the gradual loss of democratic member control through a manifold information, knowledge, and know-how gap between the members and the management. That is, a loss of that mechanism through which the social component of the objective of cooperatives is to regenerate. Now, to sum up some of the effects which come out of that, number one, the weakening the legal features of cooperatives contravenes public international law. Number two, it puts at risk the farming structure. We've heard yesterday that most of the food, or 80%, I think was mentioned yesterday, of the food is produced by smallholders, family farms, and for them, the most adequate way to organize and to survive economically and otherwise is to join and to pool in cooperatives or through cooperatives. And thirdly, the weakening the legal features of cooperatives deprives us of an effective way to regenerate social justice as the central piece of sustainable development. And sustainable development is not just a policy issue, it is also, or has been recognized that since the late 1990s by the International Court of Justice. Now, I might sound as I would oppose, so to speak, to the integration of agricultural cooperatives into agri-food chains. I'm not. Experience shows that both cooperation among cooperatives and their integration into heteromorphic value chains can contribute to the development of cooperatives, hence to the well-being of the farmer members. And maybe a study of the good cases, the successful cases, could help us finding answers to the questions we have to answer here. Much will depend on efficient and effective coordination of actors and activities within the value chains through legal mechanisms. And these legal mechanisms have to address much more complex and diverse situations than I was able to portray in this brief presentation. Now, this complexity and diversity relates to many things. I just sorted out four, which seem to me quite important. Number one is diversity by activity, production, transformation, processing, etc. The second one is the degree of intensity of integration. Is it just operational? Is it also organizational? Number three, the degree of heterogeneity of the structures of the participating entities. And number four, the question of whether coordination has to address sort of only the sum total of the various interests of the participants, or whether the value chain has or is about to develop its own purpose, its own objective. Now, taking these various situations into account and being aware, in fact, do occur very often within the same value chain, well, we turn towards the classical tools we have, and that has been discussed already. It's coordination by contract or by corporate mechanisms. We had quite a bit of discussion yesterday on the various types and new types of contracts. And also we touched upon yesterday and today, of course, more on the known legal entities like cooperatives, joint ventures, which are maybe a contract, maybe an organizational type, who knows. Well, this is a traditional way of doing and certainly very, very necessary, while of course trying to adapt these tools to the needs in the value chains. We might, of course, also try to be a bit more innovative, take the risk and find something new, especially because we find in most value chains, at least the ones I know, sort of a combination, a difficult combination between contract and organization, and also blurring borderlines between the two. And I mentioned the joint venture as one. It can be seen as a contract. It can be seen as developing at least into an organizational type. And I've just thrown this into the discussion with Priscilla before we met. You're saying something like a contract organizational law. I mean, it's just a working thing. I have certainly not thought about it sufficiently. The other point here is that where we have the value chain develop its own objective, this might give rise to something in addition to the participating. Could be that for the coordination, we need an entity as such whose main, maybe only task is to do this coordination. And the French, at least in some parts of the world, have do use the term entreprise d'agrégation. Let me finish by just pointing out to three points very briefly. One is that global value chains make many legal traditions meet, and the legal instruments we invent for the coordination will be only as effective as they are the result of very thorough comparative studies. The other issue, of course, and that has been mentioned yesterday already, what is the applicable law in a global value chain? And I think here private international law has a task yet to be tackled. And the last point, of course, is how do we enforce, if necessary, the law which should apply? That also, I think, is not quite clear. So I thank you very much for the attention and for the interest you take in what I had to say. Thank you.
Thank you. Thank you, Professor Hagen Henry. That was a great presentation and also lots of food for thought. Thank you. We'll have time to debate more during the open discussion. I would like to now pass the word to the third speaker of this session, Professor Georg Miribung. I'm sorry if I didn't pronounce your name correctly.
It's okay.
Thank you very much for joining us today. So Georg Miribung is a researcher at the Free University of Bolzano, Faculty of Science and Technology. His main of research are agricultural law, food law, cooperative law, and cooperative economic theory, sustainability in law, commons, social cooperatives, and empirical legal research. Today he will be speaking to us about indivisible reserve as a key feature of the financial structure of the cooperatives. Thank you once again for joining us, and you have the word. Thank you.
Thank you very much, Priscilla. And yes, of course, you can call me George. I think this is the best solution. So thank you very much for the invitation, which makes me feel quite honored. And also thank you very much for this very kind introduction. So now in the following 10 minutes, I will try to give you some specific information about indivisible reserves. And my observations stem from a study where I have analyzed and compared Italian and Austrian agriculture, considered a more general perspective by using the principles of European cooperative law, the so-called BECOL. So the first question that has to be raised is, what are indivisible reserves? Indivisible reserves are created by establishing specific ties of the patrimony here, the reserves of a cooperative. The result is that this patrimony can effectively be used for cooperative ends, and this is in line with the principle of disinterested dissolution. These indivisible reserves neutralize the role of capital and thus strengthen the ability of a cooperative to foster sustainable development. Indivisible reserves are considered either on a voluntary basis or because they are required by law. An example for this latter situation, or for this latter type, are mainly neutral cooperatives as determined by Italian law. This type of cooperative requires that a cooperative does its business to a great extent with its user members. And here user members are those members that use the services offered by their cooperative as compared to so-called non-user members who have a similar role to shareholders of a public limited liability company. And maybe it's also important to add that these mainly neutral cooperatives get particular or specific tax relief. Then according to Italian law, the constraint of indivisibility basically obliges the use of the resource for a specific cooperative purpose. This purpose is to provide members with a patrimonial advantage as a result of relations of exchange between the concerned cooperative and its members. This indivisibility is irreversible and intangible under Italian civil law. In addition, the law determines that it is impossible to distribute assets among the members, even if the cooperative is dissolved. In fact, in line with the principle of disinterested dissolution, the assets must be devolved to a mutual fund for the promotion and development of cooperation. Here, a concept of mutuality emerges that goes far beyond the relationship between member and cooperative and frames all cooperatives in a single system. Indivisibility does not, however, automatically imply unavailability. In fact, the assets set aside in the indivisible reserve remain available for the purpose of the cooperative, even if the law does not clarify within what limits. For example, Italian law allows for the use of indivisible reserves, expressly specifying only that this use cannot correspond to a distribution among members or shareholders. And no other limits are mentioned. But it is important to specify that, in general, the indivisible reserves must be used in such a way that the cooperative fills its social function as required by the Italian constitution. And this limit cannot be exceeded. As such, assets must be used for the cooperative's purposes, and intergenerational patrimony is also created in case of dissolution that is only indirectly available to the members, as it helps the cooperative to promote its members' needs. In fact, this patrimony aims to guarantee over time the performance of the concerned cooperative, independent of the fact that the structure of the membership base changes over time. And it is useful and also important to add that in order to safeguard the interest underlying the purpose that binds the cooperative assets, for this concern, the law installs a specific monitoring procedure. So, indivisible reserves are, as they are reserves, an essential part of the financial structure of a cooperative, in addition to a cooperative's capital, which is not fixed but variable, and thus cannot fulfill the same function as a capital in a public limited company. So, but why are they key features? Why are these reserves key features of the financial structure of a cooperative? We have to be aware of the fact that the social purpose of the cooperative requires a financial structure that promotes the interests of its members, including satisfying the economic, social, and cultural needs. In contrast to capitalist enterprises, the cooperative carries out economic activity that is not primarily profit-oriented, but instead is mutualistic in nature. The financial structure of cooperatives is therefore based on a logic of its own that results both from the specific characteristics of the cooperative's purpose and from the need to respect the cooperative's values and principles. This also implies that the various management and financial instruments cooperatives use must be compatible with the character of a cooperative and thus ultimately promote mutual exchange. These particular aspects require specific provisions that meet the needs of cooperatives and that reflect the special role of members in financing the cooperative and in obtaining an advantage from it. Since members are primarily interested in obtaining an advantage other than maximizing shareholder value, the means by which this can be safeguarded needs to be determined. All these interests then are partly counterbalanced by the interests of non-user members, as mentioned before, whose role approximates that of the role of the classic shareholder of a capitalist enterprise. And it is here, as we have seen, where the indivisible reserves play a special role. As a result of these observations, mainly mutual cooperatives are limited in their distribution of profits, and indivisible reserves contribute to the continuation of the mutualistic cause. In this context, it has been observed indivisible reserves function as a shock absorber. In other words, a cooperative must have a certain amount of these reserves to help protect members' transaction-specific investments by considerably reducing the risk that the agricultural cooperative will suddenly fail. Now, all these findings sound pretty good, but of course, various studies also discuss some critical aspects of indivisible reserves. From an economic perspective, it has been criticized that specific problems appear when the market conditions change and the members' needs to be promoted become weaker or even disappear. In general, we refer to these problems to problems of collectivity, which are fostered by a heterogeneous membership base. Because the unallocated capital is locked in indivisible reserves, a cooperative is hard to shut down. Moreover, if the remaining assets are transferred to common funds, such as the Italian mutual funds, but we find similar situations in Austria, in the event of liquidation, there is no incentive to dissolve an inefficient cooperative as long as there are assets that can be used by the members. Nor is it easy to redirect the cooperative towards new member needs, as it is generally difficult to modify the objective of the cooperative. This is caused by the free riders problem, which suggests that there might be vague alternative common needs. There are, of course, specific suggestions drawn in particular from practical experiences to solve problems like this, for instance, by using specific governance structures or by developing specific membership programs. Yet, these solutions also might weaken the concept of cooperatives. And this then finally leads us to the questions about what a cooperative should be or what its identifying features are. The principles of European cooperative law, the so-called PECOL, provide a useful tool for providing an answer to such questions. And this is necessary to counteract the phenomenon of demutualization, a process which weakens the characteristics of cooperative and which puts in danger the approved benefits agriculture and other cooperatives have for the members and for society as a whole. And weakening this concept runs contrary to the idea of creating a menu of different corporate structures that foster competition. And also for this reason, I think that indivisible reserves shall and probably must be a key feature of a cooperative. So thank you very much for having paid attention.
Thank you so much. I would like now to pass the word to our fourth speaker today, Professor Antonio Zanette. He is a Brazilian lawyer, professor, and coordinator of the specialization program in agricultural and agribusiness law of the Superior School of the Foundation of the Public Prosecutor's Office in Brazil. He will be sharing today some of the experiences in Brazil addressing cooperatives and other corporate legal structures for inclusive agricultural businesses. And it's quite interesting because we had the previous presentation mentioning, giving examples from the Italian law and European law. Now we'll see this perspective from Latin America and Brazil, and afterwards we will be highlighting some experiences from India and closing this session with the international perspective. So thank you all once again very much. And Antonio, Zanette, you have the floor. Thank you.
Thank you, Priscilla. I'm honored and I thank UNIDROIT to have the chance to participate in this webinar. My presentation will consist of two parts. The first one on cooperatives, which is a successful model in Brazil, and the second on rural condominium, which is another proposal of corporate organization for agricultural enterprise. Positive points of cooperatives in Brazil. In Brazil, agribusiness account for 27% of the gross domestic product, while agricultural cooperativism actively participating in Brazilian economy. Data consolidated by the Organization of Cooperatives of Brazil, OCB, indicates that this segment is responsible for 5.4% of the country gross domestic product. We have more than 1,538 cooperatives responsible directly or indirectly for almost 50% of the national agricultural production, considering only soy, coffee, cotton, corn, rice, and bean. Among the 943,000 members, 83% produce in areas that do not exceed 100 hectares. Small and medium-sized producers are responsible for 37% of the Brazilian agricultural and cattle rising GDP, and finding the cooperative the solution to have access to credit lines and financing. Moreover, the union among them increase their bargaining power both for the acquisition, for supplies, and for the commercialization of agricultural products in the commodities market. In the south of Brazil, 13% of GDP of state RS, Rio Grande do Sul, is made by the cooperativism. The Cotrijal cooperative, an example of success in southern Brazil, is organized through a management system with strategic planning, governance, results, and strategic partnerships. They are organized at the state level with the organizations and state federations, and the national level through the OCB. At the international level, the Association of Cooperatives of the Americas meets every 5 years and discuss principles of cooperation. What is a cooperative? It's a corporate organization, but it's from that can't be confused with any other, having unique peculiarities which makes its legal system unique. Since the 19th century in England, with the appearance of the first cooperative in Manchester, land of the Beatles, a group of 20 workers in the middle of the Industrial Revolution with economy difficulties set up a society of common interest to buy in the market and share among themselves. They made a statute and created principles that would guide them. The society is recognized worldwide if it respects the principles. In 1932, there was the first decree cooperativism. 1971 was sanctioned the cooperativism law, which is in force until today. And the Federal Constitution of Brazil introduced 6 express mentions to cooperativism, a plate goal. The first mention appears in Article 5 on the Federal Constitution, a set of fundamental rights, subsection 18, freedom of cooperatives to operate, association and cooperation are free, and state interference is forbidden. Because under the military regime, cooperatives had to be authorized by the federal government in order to be created. Who gave the authorization was INCRA, Institute Responsible. The cooperatives in Brazil are successful because of the need to cooperate. The better tax of cooperative acts, where there is no tax between the members and between cooperative and member, which simulates the production of food and larger investment, which the freedom to enter and leave a cooperative, the principle of open doors with variable social capital. The cooperatives storage makes it possible to have a better bargain on the sale of grains, and also which the purchase of supplies on a larger scale, constituting a surplus that should be distributed to the members of the cooperative. As the capital stock is limited to 30 parts, the goal is that cooperative doesn't grow dependent on a single person, and if that person leaves, it's run the risk of disappearing being a high limit of 30% for a single person. The shares cannot be transferred to other people and cause a serious problem which hurts, in which case the share is returned to the cooperative and will be paid to the hers, but cannot be transferred since there is a need for a connection to the person who adheres to the cooperative and its capital stock. Each member can have up to 30% of the capital stock. The rest is pulverized. When it comes the time to vote, this member enters with only one head, and his vote is worth the same as any other member. That is why we have the universal principle that each member has only one vote. The distribution of the result derives from the members' consideration for the cooperative, since it is a non-profit entity. It is done according to the economic index, technical reserve funds, such as the educational fund, the situation in which the cooperative relates to 30 parts. The one between the cooperative and the member, or between two cooperatives and each other to achieve the social objectives, cooperative and member and cooperative, who does it happen. The delivery of the cooperative members' production to the cooperative. For example, delivery of soybeans to the cooperative. One of the universal principles of the cooperative is intercooperation. Cooperating to trade with others who are not members and may receive production to fulfill a contract or supply production capacity. The cooperatives in their management system encompass strategic planning, strategic identity, governance, results, and strategic partnerships. 82% are male and 18% are female, printing a reality that we must encourage women to seek family succession within the agribusiness. Second part, and fine. Another possible model would be the rural condominium. The farmer living in the rural area with the production organized by the condominium can have up to 3 hectares that have been expropriated. A rural administrator is elected and the shares are divided by the number of farmers that are in the area. With this, the planting is administrated and each farmer has 20, 30 hectares. Each one plans to plant soy, buys input with better conditions, with volume of purchase and sale. Machinery is diluted among all, like the harvester. There are in some places in Brazil that are a success for small and medium producers. The combined harvester being a possible corporate model for a better organization for agricultural. Thank you all very much.
Thank you, Antonio. Now we'll shift to another country's perspective, and I would like to invite Professor Sukhpal Singh to speak with us today about producer companies as a new generation cooperatives. Professor Singh is a professor at the Center for Management in Agriculture, the Indian Institute of Management. He is the former Director General of the Center for Research in Rural and Industrial Development, and a former professor and head of the Institute of Economic Growth in Delhi. Thank you very much for joining us today, Professor Singh, and I pass the word to you. Thank you.
Thank you, Priscilla. Let me say it's a pleasure to be part of this group. I learned a lot yesterday. What I plan to do in this 10 minutes time is to share with the group an interesting experiment in India, which is now legal form. I'm also sort of interested in this because I have been part of this journey of this legal institutional change in this country, from cooperatives to what is written here as producer companies. I'll just share the screen in a minute. Is that fine, Priscilla? Okay, so yeah. So I've been also carrying out studies on this structure for the last 10 years, with a lot of case studies, which number now 60 in total, over two sets of studies in 2011 and the one I just completed in 2020 and 21. So this is a kind of structure which should interest many of the participants, because India has struggled with the cooperatives for long, given the predominance of small farmers in India, like in many other developing and Asian countries. So we have 2/3 farmers who operate less than 1 hectare of land, and another 22% farmers who operate less than between 1 to 2 hectares. So we have 88% farmers in India who operate less than 2 hectares each, really small farmers, and half of them may be doing dry land farming without irrigation. And with the cooperative history we have more than 100 years now, India has not been able to make much progress other than a few examples here and there. Like in milk, you have heard of Amul in Gujarat. In sugar cane and sugar processing, you would have heard of cooperatives in Maharashtra and Gujarat, again, Western Indian states, and other states where they're not done very well. We had plenty of cooperatives in input supply and services, but they are not doing very well, though they are local level. And if you contrast this with what has been achieved in the European world, I think there's a long way to go. So keeping this in mind, India was thinking during the last century itself, 20 years back, how do we move out of the cooperative structure which had become politically problematic, bureaucratically controlled, and not delivering the value to the member farmers who were shareholders. Earlier, my friend from Philippines talked about free rider problem. So cooperative faced free rider problem and horizon problem in India, that people were not investing but just trying to make benefits out of it. So that led to a lot of cooperatives failing, a lot of cooperatives struggling, and only few making a success. Therefore, it was thought that how do we move this legal structure to a new platform where they could, in the changing agribusiness environment globally and in India, become part of the commercial entities as part of agribusiness sector. And this was already happening in many other countries across the globe, whether in North America or Canada or Australia and New Zealand, or even some countries like Denmark, where they had this experiment of new generation cooperatives in the late 80s and early 90s, where the cooperatives moved to a new form where they restricted the membership depending on the capacity they could create or they wanted to create for processing and marketing. They also linked the product delivery rights to producer member equity. They also raised capital through tradable equity shares among members. And they also had some kind of contract farming being practiced within the membership. Of course, they retained some of the principles of cooperation like distribution of returns based on patronage and one member, one vote for major policy decisions. So this was something we analyzed at that time in the mid 90s, saying what do we learn from this in India, and how do we change Indian law to make it more relevant for the modern market times in terms of value chains and agribusiness development. So in India we have this kind of structures. Other than the one which is producer company. Earlier there were all kinds of cooperative legal sort of frameworks, starting with cooperative societies, mutually aided cooperative society, which were in each province. You could not do it if you were operating across provinces. So this was a provincial or state level legislation. Then we had self-reliant cooperatives. We had multi-state cooperative societies, mutual benefit trust. More recently, we have also one-person companies. Even individual can also set up companies now. Earlier, we had private limited and public limited and partnerships. Now, even individuals can set up a legal entity of a company. And this innovation I'm going to talk in a little more detail with you is what is called producer company. This law came into being in 2002 and became operational from early 2003. So we are into it now almost for 18 years, and there are 7,000 plus such farmer producer companies in India, most of them being in agriculture sector. And Sri Lanka was the only country in Asia which has tried this form of cooperative company or new generation cooperative in the 1990s. But they mostly failed there because there the state was the one which was organizing and promoting these entities. Unlike India, where we have multiple stakeholders who are sort of setting up or helping farmers set up these companies. So I will talk about the producer company. What does it mean in India? In India, it means now under this new law, which is a separate chapter in the Corporate Companies Act of India, that 10 or more individual primary producers or farmers, or 2 or more of the institutions, which may be pre-existing cooperatives or societies or whatever trusts and so on, or a combination of these can set up a producer company. And they can, what I call, do anything under the sun, any business, right from production to import, export and whatnot, and they'll be treated like a private limited company in India. Because this is under the same Corporate Companies Act. So they are governed by the Registrar of Companies, unlike the cooperatives, which were being governed by the Registrar of Cooperatives. And that was very, very bureaucratic and sort of dominating kind of institution, which could supersede boards, which could just take over cooperative, which would ask them to take permission for every little thing they wanted to do as a business entity. So here there's no such differentiation between a private company and a producer company. Membership is open, unlimited, voluntary, but the liability is limited by shares. And in fact, some companies are trying this, producer companies are trying it. Membership can also be limited if it is needed, like a new generation cooperative, like they were doing earlier in the 1990s. One member, one vote principle is retained, irrespective of shares held. Only when there is a producer institution, which is a member, there you can restrict the voting rights if needed. Shares are transferable within the active membership only. They can't be traded outside So within the membership, you can transfer your share to the other existing members if you are not interested in the business of the company anymore. Limited return on capital, again, the cooperative principle is retained, but you can give patronage bonus or bonus shares. They are free to form joint ventures, subsidiaries, or collaboration with private or public entities up to the 30% of their capital equity, including reserves. They can also buy the shares of other producer companies. They would have minimum of 5 and maximum 15 directors, but the first year they can also have more than 15. They can also have experts as co-opted directors who will not have voting rights, 20% of the strength of board. They must start business within first year of registration. If they don't, then they can be struck off the register of the records. The multi-state cooperative societies, which is another legal structure in India, can also convert to producer companies. And if they don't find it good enough, they can reconvert back to the original structure. That is also permitted in the law. And it emphasizes member education and cooperation among producer companies like the ICA principles of cooperation. So I call it cooperative company. It's a hybrid structure which has retained the essentials of cooperative principles, but given business freedom to the cooperative company to become competitive and join hands with other market-based structures so that it could get better terms for their members while working within or along value chain players. These are differences between a cooperative company. I'll go into details of it because I've already talked about it in quite a bit detail. I can share that with you. So there are 7,000 plus such companies now with 4 million members. There are different kind of promoters, but the pace has picked up only in the last about 6-7 years, ever since the government of India and many national and state level agencies took upon themselves to take this route to promote farmer collectivization. So now the government of India is going to promote 10,000 entities over the next 5 years with plenty of financial and policy support. As you can see, most of them are producer companies and in agriculture. Some states are leading the way. Women, all women member pieces are very few, less than 200. And if you can see, a lot of them also having some best practices because of which they are making a difference to the farmer situation, unlike the cooperatives. So, for example, many of them are having very large member base. Their membership runs into thousands of farmers because India's farmers are small and marginal, with very small equity. So they have to have that membership base to have a scale of activity. Some of them are practicing mixed membership, that they also have medium and semi-medium and large farmers as part of their membership, because in local area you can't exclude some people and include only others. So some of the government programs have this condition that if you want support from the government, you must have so many % of the total membership which should be marginal or small producers. A lot of them have come up based on the existing structures of water users associations, farmer interest groups, self-help groups, and such collectives which were existing under either an earlier existing legal structure or informal structures which were not legally registered. There is one company, at least one producer company, which has gone for a joint venture with a corporate, very large corporate, Tata's in India. So they have set up another company in collaboration Tata's as a joint venture. Some of them are using franchising route to both sell inputs to farmer and members and non-members, and also to sell the output. Many of them are involved in contract farming with multinationals like Pepsi and McCain. And many of them are also bringing crop insurance to farmers to reduce their market production risk, and contract farming to reduce their market risk of price and availability of market. And many of them are also making good use of government schemes, for example, procuring for the government food grains. So they involve in that, they get a permission to do that. There are different models. One of the models which is promoted by the National Dairy Development Board, they are promoting state level or province level milk producers companies They are going for asset light and low asset turnover ratio, that they don't invest in permanent structures. They basically deal with other players in the market to buy and to sell, even milk and milk-based products. A lot of them doing high value crops as part of diversification. For example, bananas were introduced in Uttar Pradesh by the producer company for the first time by bringing it from South India. Some of them are involved in supermarket retailing. They have taken franchises from the state government on state-run supermarkets in Bengal. Many of them work with organic and sustainable players to sell organically grown or naturally grown produce. They deal with multiple market players. They keep their options open. Some of them brought intervention in local market, for example, spot payment. Some of them dealing with wholesale markets by selling for the farmer there. And some of them have made good use of warehouse facility and warehouse-based receipts to get loans for farmers so that they don't have to do distress selling at the time of harvest. Many of them could not participate in futures market because it's too risky for them to put small farmers equity, a small farmer business into this kind of market. They are facing some problems despite all the support by the government. For example, the membership buy-in is still low because the farmers don't appreciate how their own company could be different from their own cooperative, because they have very negative experience of cooperatives. So they are still not able to differentiate in many cases. So member awareness about their own entities low. Ownership is not there because they contribute only a few dollars each as equity. Banks are still not willing to lend because after all it's about lending to agri entity, lending to small farmers entity. They still treat producer company as a cooperative. In fact, Government of India has also sent a sort of directive to all the banks and other agencies saying, treat producer companies like a cooperative. So that actually creates a problem for them to, because they can't give big collaterals and they just perceive another set of cooperatives. They can't get now government grants because they're commercial entities. They are like a private limited company. Cooperatives earlier could get grants, but these companies cannot get grants, so they have to mobilize money from other sources, or they have to have a non-profit entity as another partner who can root in some of these grants. There are a lot of governance issues, management capability issues in terms of lack of professional management, lack of market orientation, lack of business plans, lack of value chain mapping, and so on. The biggest thing we found in our case studies was that the market linkage is still not as much, especially on the output side, as it should be to make a tangible difference to the farmers' incomes and livelihoods. This is the book which we had published in 2011 on the first study, which has 24 case studies. And now I'm up with another manuscript which has 35 case studies across 5 states. And the earlier study had covered 4 states for these 24 companies. So I'm happy to share more insights from field research with you. Thank you very much.
Thank you, Professor Singh. Now our last panelist of this session, I would like to hear from Ms. Monica Canafolha. She will be speaking about the future legislative guide that UNCITRAL is developing on limited liability organization and its adaptability to agricultural micro, small, and medium-sized enterprises. Monica Canafolha is a legal officer at the International Trade Law Division of the UN Office of Legal Affairs, which is the substantive secretariat for the United Nations Commission on International Trade Law, UNCITRAL. She is currently serving as a secretary of UNCITRAL Working Group 1 on micro, small, and medium-sized enterprises, and coordinating the UNCITRAL presence on social media as well. So, Monica, thank you so much for being with us today, and please, you have the floor.
Thank you, Priscilla. Good afternoon and good morning to everyone. I hope I had some problems with the camera. I hope we solved the problem. I hope you can see me, and most of all, I hope you can see the screen that I'm about to share. thank you to UNIDROIT for asking us to participate and to contribute to this very interesting initial steps, kickoff of your new project. What I'm going to do is just share a snapshot of this draft UNCITRAL legislative guide on limited liability organization. And I assume that our Madame, the chairperson of UNCITRAL Working Group 1 might also be, who's very familiar to UNIDROIT because he's, of course, very attached to UNIDROIT, is taking part to this afternoon session. I know for sure that two of the delegates of Working Group 1 are speaking in the next session. So if they have they wish to contribute to this presentation and share their opinions, please feel free to do so. What is this UNCITRAL Limited Liability Organization? First of all, I don't have to explain and to repeat what is already well known to everybody, that MSMEs have a crucial importance in, I would say, most of the economies of the world, whether it's north, south, east, or west. At the same time, they face several challenges. And although the MSMEs might have, the micro, small, and medium-sized enterprise might have a different form according to the legal traditions, to the country where they are established, we can see that they face the same obstacles, which are difficulty to access credit, challenges in accessing credit, heavy impact of the legislative and regulatory measures at country level, limited source of employees, difficulty in transferring or starting a business, etc., etc. Based on and for these reasons, to kind of contribute to meet and overcome these challenges, in 2013, the UNCITRAL, the UN Commission on International Trade Law, agreed to include work on removing the legal obstacles for MSMEs into its work program. And it agreed also that such work should start with looking into the simplification of incorporation, and the simplification of which means how to facilitate business MSMEs startup in very non-legal terminology. The result is a text that is going to be submitted, it's going to be presented to the Commission, to UNCITRAL, at its forthcoming session in July this year. And we hope that the Commission can consider that text and consider and adopt it as a legislative guide. What is the topic? The topic is a simplified limited liability entity. This simplified limited liability entity is a very flexible business form that has been developed by the working group based on the experience of several countries. Again, countries from very different economic background and very different legal tradition. And the aim is to facilitate MSME startup, and also when this is required, to facilitate MSMEs transition from the informal economy to the formal economy. This simplified limited liability entity that has an interim name as UNCITRAL Limited Liability Organization, the name will be the final name will be different. This is a kind of let's call it a working name that was given throughout the negotiations in the past years. The UNO is a super simplified form that wants to provide an economic inclusive framework, and it is based on not only on the, as I said, on the experiences of many different countries, but it's also it will also result into a standalone legislation and a standalone law. This legislative guide, the draft legislative guide, doesn't mean to reform existing company laws in any countries, to simplify existing company law in any country. The draft legislative guide intends to, in fact, create a new regime, a new legal form. This is the one of the main features of the draft guide. The draft guide, this ULO form is based, first of all, on a paradigm that you can see there is think small first. And we hope that we have been successful in capturing this catchy sentence, catchy phrase. Think small first means, first of all, try to provide a tool that is relevant and important for micro and small businesses. Put yourself in the shoes of the micro and small entrepreneurs and draft a text, a tool that could be useful primarily for them. And because of this, it is the UNLAW. It's actually simplified entity that moves away from the traditional, the formal, hierarchical models, and it's quite of a horizontal, I would say, flat structure. Who is the UNLAW for? The UNLAW is in a way, I call it colloquially, I call it in a familiar way, I call it it's a neutral business form. There is a recommendation in the guide, and very clear, the recommendation sets that the ULO can be established for any lawful commercial and business activity. And that's it. There are no other indications of any commercial or business sector in which the ULO could find, could be used. Actually, can be used for anything that is lawful, and it has any, commercial or business implication. There is, however, and this is the only time in the draft legislative guide, mention of agriculture. And that's because some of the delegations had a concern, some of the delegations participating in the work of Article 1 had a concern that not in all legal tradition, the term, or in all states, the term commercial might include agriculture. So they wanted to clearly specify in the commentary of the draft legislative guide that agriculture is to be considered within the group of commercial activities. A very quick, let me open a very quick remark that I forgot to clarify at the beginning. In the UNCITRAL type of work, a legislative guide is a text that is, I would say, a compilation of best practices. There is a policy part, a commentary part, and then the commentary part is supported by a series of legal recommendations. So the guide, in terms of one last thought about the type of activities for which the ULO is for, the interpretation of the terms commercial and businesses, it should be very, very broad. What are the features? Well, the general features, first of all, the most important features are two: the legal personality and the limited of the ULO, and the limited liability of its members. These are the founding features of this text, of this draft, of this entity, which is quite important because not in all states legal forms that are typically used by MSMEs are recognized limited liability for the MSMEs entrepreneurs. And you know what it means, legal personality and limited liability for the ULO members. It means that you can partition the assets of the ULO and the assets of its members. The ULO is formed upon registration with the business registry or any other relevant entity in the state that carries about that function of registering businesses, and minimum information is required. There is no minimum capital, sorry for the typo, no minimum capital required at the formation to form the ULO. So the ULO can be formed without any capital. And members of the ULO, what I said, why I said the ULO is a flat, is a horizontal structure, because members of the ULOs have equal rights. They may decide otherwise, but the default rule, the default principle is that they have equal rights. The other big aspect is that most of the governance, internal governance of the ULO is left to the agreement of the members. Members are really, the ULO is really based on the principle of freedom of contract. Clearly, the working group was concerned about protecting creditors, third parties, dealing with the ULO, protecting the states. So, in fact, there are certain rules, certain standards, certain rules in the draft guide in order to ensure the transparency and protect third parties. For example, managers of the ULO have a duty of care and loyalty to the ULO. In order to reduce the risk that they can act in an opportunistic way. There is a prohibition of improper distribution, so the ULO cannot distribute any income if after the distribution the ULO is unable to pay its debts or is to face its liabilities, and this is in order to protect third parties, and in order to avoid that the ULO assets, of course, are not sufficient to satisfy the obligations of the ULO vis-a-vis third parties. The ULO also takes, the draft legislative guide also takes into consideration that the ULO members may not be sufficiently experienced to draft their own rules for the ULO, their own, what they are called organization rules, which is what in many states is called operating agreement. So there is the bulk of the draft guide includes several default provisions that kick in if there are gaps in the organization rules, in the agreement of the members in terms of how the ULO should be structured, the governance of the ULO should look like, and also some default provisions that can protect the ULO members against the circumstances, against events that they may not have foreseen. For example, a default provision of the ULO is that the ULO members will be the managers of the ULO. So unless they decide otherwise, the ULO is going to be managed by its members. If they want a different structure, if they want to hire an external manager, they can do so, but they have to do it. So, they have to think about it and do it. The transfer of rights is another, default provision. You can transfer your rights If you don't want any longer to be a member, you can certainly transfer your rights if there is the agreement of the other member. And, you know, although the members may decide in their organization rules, they don't want to allow for transfer of rights. So this is, in a way, how the legislative guide is trying to help the member, the entrepreneurs who might want to use this structure in the future. I mean, assuming that several states, assuming that states will actually enact legislation based, assuming and hoping that states will enact legislation based on this guide. What is the relevance for MSMEs? I said already at the beginning that the idea is to encourage startups. Why? Because the structure is simple, the rules are very accessible and easy, the structure is flexible, the UNO is being developed thinking of the micro businesses, but the structure is also a structure that can be used as the business grows and progresses. So it can be used also for medium-sized businesses, and it can be used for smaller and medium-sized businesses as well. The recommendations accommodate the evolution, the progress from micro to medium-sized. It's also a text that encourages the use of technology. For example, the organization rules that can be recorded can be recorded. The draft guide doesn't require that they are in writing. Simply says that can be recorded. So it can be recorded in a WhatsApp, for example. Another advantage is the legal recognized identity and the fact that with a legal recognized identity, the MSMEs can access credit, social security, hire employees that are not just family and friends. It's easy to be integrated in value chains because you have a formal identity. It's a benefit for those. It's a benefit for the businesses in the working in the informal economy. Both for those businesses who never thought of the option of formalizing, like street vendors and artisans, because it's too complicated for them, but also for those businesses who actually are using the informal economy as a launch pad, as a step to transition sooner or later to the formal economy. Farming, as I said, there is no, UNO is for everything. It's not a specific connection other than the one that I mentioned before to agriculture. And certainly I'm not an agriculture expert or an expert on legal structure for agriculture enterprises, farming enterprises. I gave it a thought, and we will actually think that what is the advantage? Well, the advantage is that it offers limited, if applied to agriculture, to farming enterprises, it offers limited liability protection to the entrepreneur. It is easy to establish, it is easy to manage, and it is easy to transfer. It is easy to transfer to your next generation. So that might be an advantage and a feature also to consider in the program area. I'll stop here. Harry, be very happy to take your questions or comments. And as I said, all those who are in this webinar and are connected to Working Group 1, also to Working Group 1, feel free to. Thank you, Priscilla, and to UNIDROIT again.
Thank you, Monica. Thank you very much for sharing also this information in this interesting work that UNCITRAL is doing. I think all the presentations were very interesting in the sense that we verified the session served its purpose, which was to map the different possibilities of legal structures and how that may affect the organizational form of the business. And this is also important, as we will see in the next session, on how the legal structure may impact the access to finance as well. We have passed a little bit of our time, so I don't know if anybody has any question now. What I would propose is maybe we do a short break, a 5-minute break. We do the next session, and if everybody can stay with us or send their questions for this panel to me, we will touch upon it at the last session, where we will be talking about the next steps of the project. And we will be rediscussing about several of the features that were mentioned here and questions that were posed. So does anybody want to ask any question now from the panelists? Or can we move to the session 6? Thank you.
Sorry, may I ask a question very quickly?
Please.
Yes, right. So I would be very grateful if the experts could consider whether this project to be undertaken by the 3 organizations might want to have also as an objective the creation or the analysis of structures that will favor a movement towards formality, which is something which has been mentioned by the ancestral representatives, like Monica, and which is, is not an evident part of the project, but I thought it was very interesting. So if you think that is the case, we have very little time for discussion, but feel free to share with the Secretariat any thoughts you might have as to how the legal structures might help move towards formality in the agricultural environment. Thanks.
Thank you. Thank you, Professor Ignacio. Anybody else wants to have the floor now?
Can I ask a question?
Please do. Thank you. Professor Fabrizio Cafaggi, you have the floor.
My question is about the assets and the ways in which, especially in the UNLO, but also in the other legal forms, it is possible to dissociate land ownership or tenure from the ownership of the other assets of the agricultural enterprises, because one of the problems that we're facing is that because of family enterprises, ownership of the land and the ways in which the activities run might not always run together. And so I was wondering whether, from a corporate standpoint, is there any way that the ownership of these 2 assets, land and machinery, equipment, can be dissociated, also in light of the possibility of the next generation issue that Monica was talking about? These enterprises have an issue of stability over time, and it might not be necessarily the case that land ownership needs to be transferred in the same way as the other type of assets of the enterprises.
Priscilla?
Yes, please. Please,
Yes, that's a very good point brought to the table by Fabrizio. And I think my basic message in my first 2 slides is that the choice of legal entity is in a continuum, meaning it is precisely because of this issue of family farms contributing assets in exchange for shares, either in a cooperative or a corporation or even an LLO. That is why my basic message is the choice of legal entity moves across the continuum of the community going to a for-profit. It could also move across the continuum of the value chain. So just to go deeper, you could have a situation where you can have a formality of organization in the inputs. You can have where it is a non-profit because you're just looking at economies of scale in purchasing fertilizer, create a new legal entity of smaller groups of farmers using an LLO with 2 or 3 hectares per farmer with 3, that would be 9. And that would be another legal entity. I think the first thing we need to break in this discussion of legal entity is that there is just one across the continuum of time or the continuum of the value chain or across. And I think that's the flexibility. That's also a response to the question of Ignacio on the issue of formality. I think that's the basic message I wanted to bring across.
Sorry, may I? Priscilla?
Please, Ignacio.
Thank you, Virgilio. That was very interesting. Changing corporate form has a lot of consequences in terms of liability, in terms of, so, you know, it has to be, I'm not per se saying that can't happen. I'm just saying, you know, if we're going to go down the road, a lot of thinking will need to be done as to how to do that without undermining the rights of the people and the parties that interacted with the business before the business changed its form. This is a very complex matter, I think. Anyway, I am very interested in FAO's position, and Carmen Bullón from FAO answered, I think, or asked a question, I'm not sure, to me in the chat, and I would ask her if she could perhaps come in and explain what she means by her question in the chat, because this is Carmen there?
Yes,
Carmen.
yes, indeed. I'm sorry, yeah, I just decided to put in the chat because maybe this is something that you have discussed already. So I find that the discussion you raised is extremely interesting, how the legal framework can be conducive of improved formality. It's an issue which in the FAO we work on a daily basis, how legislation can really improve not only the formality of legal entities, but also formality in general, and also support to implementation. But in this discussion, I see like different points associated. One of them, let me put my video. One of them is how the law per se can support formality, and another one is how the process of drafting that legislation can also foster formality. And then the third point could also be how the involvement of stakeholders also in the implementation of legislation can facilitate formality. And the example I have on top of my head is the certification of products through participatory guarantee systems that give the entity, the group, and producers association or agricultural enterprise the possibility of self-certifying the quality of their products. That's just an example that came to my head. So the fact is that I'm not sure that in the process of developing the legal guide, we can enter into analyzing all these different processes. So I'm just dropping the idea there for brainstorming.
If I may, just to say that we don't need to define this now. Of course, this can be defined at a working group stage, but what the main purpose of this workshop is to identify these type of things, and you know, this tripartite, this triple division of this item, and that it is an issue is very useful by itself. So, you know, we don't need to decide whether this will be part of the work, but knowing it's there is very useful. So thank you.
I think for us, this could be an extremely interesting discussion.
Thank you, Carmen.
Can I ask a clarification?
Yes, please.
To both Carmen and Ignacio, because it seems to me that there might be different reasons why you want to formalize. And it is not necessarily the case that you formalize in the same way depending on the functions that you are pursuing. So let me give you two examples that come to my mind. One is the formalization associated to access to credit. It is very hard if the enterprise does not have a legal form that the enterprise is going to be able to access credit. But another reason is the black market. If that enterprise doesn't exist, maybe a lot of gray areas, including labor, might be hidden. Now, the reasons, and a third one is tax. But these are three different reasons why you want to formalize. And it is not necessarily the case that you formalize to enable access to credit. You do it the same way as you do it for tax purposes or for work purposes or for technology purposes. And so if I'm correct about this, then Carmen, would you think about, or are you thinking at FAO about different types of formalization depending on the function, or you are thinking about simply making these agricultural enterprises emerging from the informal to the formal with a single route?
What I had in mind was the second option, just passing from informality to formality, not only to facilitate the access to the credit or to the market more generally, but also for issues related to the personal liability of the members of a cooperative. Or I mean, there are many reasons why a group of small producers may want to formalize the relation, or may want to create an agricultural enterprise. I would not have in mind different types of entities depending on the reason why they are formalizing, but I'm not saying that that's not something that may move also different types of, I mean, the decision of the type of entity that's created. To be honest, what I see in the field is that this is sometimes not a decision that is that well thought from a theoretical perspective. Very often, what I found in practice are groups of producers that decide on one specific type of association or enterprise or another, based on what the Extension Service has recommended, what's the easiest way to do it, where is the closest office where I can formalize myself. This I've seen it often. But anyway, if there is clear guidance, and this is also part of the response I gave before to Professor Tirado, part of the process also is creating an enabling framework for this, for the group that has the intention to formalize, to make informed choices. So in a sense, the process of developing a legislation, or the process of implementing the legislation, the processes around it do also have a role to play. That was my major point.
Thank you, Carmen. I would like to pass the floor to Maria Chiara, UNIDROIT's president. She asked for the floor.
Yeah, thank you, Priscilla. I couldn't use my microphone now, but I hope you can still hear me. I wasn't just, I mean, you already, especially Carmen, already introduced some of the points that I wanted to mention, but I just, just to completing somehow Monica was saying on the UNLO. I think that when there was this exercise on UNLO that was not done for agriculture, but in any event, when the old discussion went on UNLO, it was also realized that there was still a gap between the time when you get formal by way of registration of your activities and the establishment of a legal entity. which what was interesting for UNLO was the limited liability issue, and saying to be sure that you could guarantee limited liability, but still in between there is room for different kinds of cooperation that might also be reached without the establishment of a legal entity. Sort of cooperation by way of contracts, and I mean Fabrizio and Paola know what I'm speaking about, because we as Italians tried to somehow to propose also a model that we have on networks of enterprises, which was a kind of instrument that was alternative to cooperatives, was a bit more articulated than what you might have in a cooperative. And but you know, I think that there is still room to really getting the process of enabling some form of cooperation specific to the function of a per se function at one point of time. So much flexibility in the use of organization by way of contract to permit to use these according to the needs. For instance, if you have to protect intellectual property, or if you have to buy something jointly, some sort of some instrument that is really flexible and complements and addresses the issue that yesterday our colleague from IFAD mentioned, that there is a gap between when you are too small to get not only credit, but to really, you are too small to act in the market, and all of a sudden you have instruments where you are too big to benefit of those. It's really in between that there is a need for some legal structure. So I think we should somehow work on that perimeter, which is indeed what also at UNCITRAL was considered to be a gap that was not covered, not even by the model that Monica presented. So that is something where possibly it can be worked.
Thank you very much, Professor Maria Chiara Malaguti. Does anybody else want the floor now, or?
Can I say just a few words, but I can speak later.
Yes,
no problem.
Thank you, Paula.
Oh, just a need for clarification, especially after the last intervention. I thank Professor Malaguti and President Malaguti very much for that. It seems to me that it could be useful to distinguish the problem of corporate structures between cases in which we are looking for legal identity of agricultural enterprises and cases in which we are looking for a structure through which more agricultural enterprises may cooperate. Of course, when we come to cooperative companies, for example, the two aspects might be pretty much, combined, because in fact, the cooperative company may also run, a separate agricultural business as well, and the farmers that belong to the cooperative have their own agricultural enterprise as well. But maybe if we reason of the two level distinctly, that could help. And the second question, but we can speak about that later. If one was more a factual question to all the speakers that spoke about cooperatives in different context environment. Some of them, I don't remember the name, sorry about that, apologies, said, well, in fact, the cooperative is a structure to govern the chain. The chain is inside the cooperative. And this brings me to another distinction, which is important. The case in which the cooperative works horizontally, because puts together enterprises that operate at the same level of the chain. They're all farmers, for example. Cases in which cooperatives were also, at least partially, also vertically, because they also include businesses or entrepreneurs who work at different level of the chain. And in that case in particular, the cooperative might have a coordination function in respect of the chain. is it more the case? I mean, normally, at least from part of the experiences, cooperatives work more horizontally than vertically. But do we observe in practice a phenomenon which also vertical coordination occurs within the cooperative as such?
Thank you. Thank you, Paula. Would any of the speakers like to respond to Paula? Thank you. Please, Professor Hagen. Thank you.
Well, this is in fact a very, very interesting point you raise, and I touched upon it very, very loosely without going into detail. So historically, and I think that is important to understand, historically, the original idea of cooperatives was to have the whole vertical chain from the producer to the consumer, and for reasons which we understand. So when you read the bylaws of the first cooperatives in the mid-19th century, they all spoke about that. And for quite some time, that has been the case, that they tried to not only cooperate horizontally, but also vertically, just to ensure that the value added, because the value added normally is somewhere else, not at the producer side, will remain in the chain and be distributed among all of these participants, from the consumer to the producer. And what you see now ever more, even where you had these quite successful vertical structures of cooperatives, they disintegrate and they integrate. I mean, the different parts, the processing or the producing, the distribution, they disintegrate and reintegrate into value chains which are driven by other actors. So from cooperating, they now become the competitors of each other. And that has caused in quite a number of countries, especially in Europe, enormous problems and tensions between cooperatives. Now, where we go in the future, who knows? But that is part of why some cooperatives are still quite reluctant, and they oppose even to join value chains, because out of this tradition, there's a different thinking. And the interesting thing is in these vertical chains, especially, that you have quite an interesting mix of hierarchical and heterarchical structures, which in the same organization. And that makes it, I think, and I don't want to advertise now cooperatives, that's not my point, but to get this idea out of that and maybe redo it for the purpose of other value chains, because I think there is some value to be taken out of that.
Thank you very much.
Thank you, Professor Hagen. I would just like to mention that in the chat, Monica Canapolia has added a comment. Monica, would you like to share that with us? And also Jennifer Bear, please.
Yes, thank you. I didn't want to, interrupt the discussion. Simply an aspect that I forgot to mention, and given the current, round of discussion may be relevant. It is that in the draft guide, in fact, there is a possibility for a legal person, and the guide recommends a very broad interpretation of the term legal person that can be a member of the UNO. And so, for example, a cooperative can be a member of an UNO. Another legal person can be a member of the UNO. That also, of course, it's an option, and the guide is also very cautious for reasons of beneficial ownership or reason of transparency. So it actually suggests that the final decision on this particular aspect is taken by the state, but it's not ruled out. And in a similar way, the fact that a legal person, member of an UNO, can become a manager of an UNO is also left to a decision of the state. It's not completely ruled out. And just replying to a question that I've I'm seeing now on the chat. Does UNO foresee a single member? Yes. And UNO is also for a single member person. Thanks. Thank you, Priscilla.
Thank you very much, Monica, for the clarification. I would just like to mention, we do have a question from the audience, and I'll bring that into the discussion as a last point before we close the session. So Marco Nicoli from the audience is asking Monica if the UNLAW foresees also single members.
Sorry, yes, you can have the UNLAW can have a single member, yeah. A single member or multi-member, yeah. Thanks.
Okay, thank you very much. This has been a very insightful session, and I would like to ask you all to continue with us until the 6th session, where we will come back to discuss again what may be the focus, the topics that we will be focusing on in the next steps of this project. As we have mentioned here throughout these 2 afternoons, this is a consultation webinar where the purpose is for us to try to identify the topics that require more thinking, right? So please stay with us. We'll have to adjust a little bit of the agenda, and I would like to propose that we take a short break, 5 minutes, and we come back. It's 15:18 now. We come back at 15:25 to start at 15:30 the next session on agriculture finance and access to credit. If everybody agrees, that's our plan. Thank you very much. Hello everyone. Thank you for joining us again. I will pass the floor now to Professor Ana Veneziano, Deputy Secretary General of UNIDROIT, for the moderation. She'll be the moderator and chair of this 5th session of the consultation webinar. Thank you very much, Professor Veneziano. You have the floor.
Thank you, Priscilla, and good morning, afternoon, and evening to all. I'm very pleased to welcome you to this 5th session of the workshop. And this panel, as you see, will focus on an issue that has been repeatedly mentioned throughout the workshop as constituted one of the main challenges for inclusive access to adequate domestic and global agricultural markets, that is, access to credit. And the panel will discuss how the legal structures of enterprises we discussed so far impact on financing. We're very grateful to this distinguished panelists who accepted to share their rich and diversified expertise with us. But before introducing them and giving them the floor, I was asked to very briefly introduce the topic, and I will mention only 2 points. So the first is the starting point from UNIDROIT's perspective, what was done so far. And the second point is the purpose of the present panel, that is the potential added value of an instrument focusing on the structures of agricultural enterprises to enhance access to credit. And this is what the panelists will talk about. So to go back to the first point, as you know, UNIDROIT has devoted a particular attention to promoting access to finance in general, but also specifically in the agricultural markets, focusing on the private law aspect, and various instruments approach the issue from different perspectives using different structures. On the one hand, for example, we have a specialized treaty, the Cape Town Convention model, through its 4th protocol, the MAC protocol, which provides an international legal regime to facilitate asset-based financing of high-value agricultural equipment. So here we're talking about traditional loans using a high-value movable as collateral, but also leasing and also sales with retention of title, so a functional approach. And despite the fact that it's focusing on high-value equipment, is not only targeting large enterprises, but also smaller scale ones, especially if they pull their resources together. So this is probably one possible link to the structure of enterprises. Then we have the instruments that were repeatedly mentioned, developed in the framework of the FAO and IFAD, the legal guide on contract farming, and it has already mentioned that financing is considered, for example, as one of the elements of the bilateral relationship, as an input of the contractor. But as it was already noted, there is also a reference to it in the chapter on the parties, multi-party relationship. So one of the questions is how to go forward and look at possible structures in relation to financing. And then the ALIC guide, which focuses on investment contracts on agricultural land, and focusing on the importance of structuring the investment relationship in a responsible way, taking into account economic, but also social and environmental concerns. And again, here it was already mentioned how the importance of the structure of formal and informal participating entities. And finally, we have ongoing projects, a model law on warehouse receipts and a model law on factoring. Of course, the model law on factoring is not specifically devoted to agriculture, but it can be very helpful. They both are alternatives to more traditional collateralization, and they're very suitable for SMEs in the value chain. And in a way, they try to overcome the challenges in accessing more traditional modes of financing, but this is maybe what our panelists will help understanding better. So what is lacking? What are the questions? Main question, what is the impact of the structure of agri-enterprises on their financing? What is, this is a question that was already posed, what is a specific role of formalization? And what corporate or other business structures better help overcome the present challenges to an inclusive access to finance for SME, to support SMEs' access to credit when more traditional ways might not be available, how to target disadvantaged groups. This is also something that the panel will discuss, and how to turn technology into an opportunity. So all themes that we have already seen in the workshop, but targeted to financing. So let me, however, now, without further ado, turn to our distinguished speakers. And I will introduce the first one. And let me also refer you to the bias, which are larger biases in the agenda. So Zanette is Senior Legal Officer with the Department of International Law of the Secretariat for the Legal Affairs at the Organization of American States. She focuses in particular on matters related to private international law. She also has an academic and professional background in the field of law as applied to agriculture. Her title, as you see, is Legal Structure, a Prerequisite for Credit, so a good contact and relationship with previous panels. Zanette, you have the floor.
Thank you very much, Anna. Thank you to the organizers for the invitation to this event and the opportunity to participate in this panel. It's a pleasure. As was mentioned, the title of my presentation, Legal Structure, a Prerequisite for Credit, also doubles as my main message. So that's it. No slides, but I would like to try to unpack that message and in the context of what has already been said. Let me begin with a segue from the last session where we heard about the work of UNCITRAL Working Group and the UNLAW. And as a complement to that, at the OAS, we have a regional instrument, the Model Law on the Simplified Corporation, which was approved in 2012 and is based largely on the success of the Colombian legislation. For those in the audience who don't know, I should maybe just mention briefly that the OAS is a regional intergovernmental organization with 35 member states. And so the OAS General Assembly has encouraged domestic reforms based on that model law and has given us, the Legal Secretariat, the mandate to disseminate that model as widely as possible. We have just compiled a report that I'm hoping that it's in the process of being published right now. I was hoping it would be ready for today. The report's on the status of reforms within the region based on the model and covers reforms by 11 states. I think this could be prove useful to the UNIDROIT Secretariat in its work in this project on legal structures for agricultural enterprises, together with that of UNCITRAL, of course, to see how states take these legislative guides and these models and then adapt them to their own particular legal context. In this report, part 1 includes the country reports, and then part 2 reviews what we call 12 key elements that we describe as the 12 emerging international standards for simplified incorporation. These would include, as you'd be familiar, legal personality, limited liability, no minimum capital, broad purpose clause, and then particularly important in the regional context is that there are no mandatory intermediaries required for incorporation, which can be very important in states that require often a notary to essentially incorporate or take steps. So this adds to the cost and complexity, which then precludes incorporation from many small medium-sized businesses. So that's just by way of segue from the last session where we were looking at legal structures. I would like to just step back for a moment and recall the objectives of this UNIDROIT project, which were outlined in the introductory session yesterday: access to markets, increased size and soundness of the enterprise, and then access to resources. So in other words, this new project, the structure, the agri-enterprise in and of itself is not enough. It is merely a means to an end. So it's important to bear this in mind. From our own experience, as we in the Secretariat of the OAS have experienced, ultimately we have to sell the product. I have to promote the model law on the simplified corporation. Thankfully, at the last minute, we were able to change the title. Originally, it was the Simplified Joint Stock Corporation. And among our member missions and diplomats who are under a constant barrage of news about COVID, migration, climate change, political upheavals, in other words, important issues, it's very difficult to explain at times why this work is important. I have been in a conference, a room full of diplomats and policymakers speaking about the need for better access to credit. And yet, when I approach the same individuals about wanting to discuss the model law on secured transactions, for example, or the model law on the simplified corporation, I'm met with a blank look, and it's understandable. This language is not common currency, not to those in the foreign service or diplomacy. While the issues that we are discussing in this seminar are fairly obvious already to most of us here outside of this room, we need to find a way to get that message across. We need to find a way to make that connection. First of all, to gain access to credit, you need a formal business structure. And then secondly, to encourage businesses to formalize, that process needs to be simple, fast, and affordable. So thankfully, we can actually point to the Sustainable Development Goals for support in this regard. As was mentioned yesterday already by the FAO General Counsel, Target 2.3 includes reference to, quote, equal access to financial resources, unquote. And to that, I would also like to mention SDG number 8, and specifically Target 8.3, which perhaps responds to Professor Tirado's question on formalization, because that target seeks to promote policies that encourage formalization and growth of MSMEs, including through access to financial services. And then, of course, we have the World Bank in its work on enabling the business of agriculture. Access to credit is one of the indicators considered as in the doing business reports. So briefly mentioning, as most here would already be familiar in terms of rates of informality, globally, most of the world's employed population is in informal employment, representing about over 60%, which includes the agricultural sector. Persons living in rural areas are twice as likely to be engaged in informal employment as those in urban areas. And in the agricultural sector, it is the one with the highest level of informality. Regionally, in the Americas, these rates of informality vary widely, sub-regions and by country, of course, but the characteristics follow the global pattern. Informal employment is higher in the rural areas, and among economic sectors, it's highest in agriculture. So then what are the consequences of this for access to credit? For informal businesses, it's either no credit or credit by informal means, which means high interest rates and also, more importantly, outside of the protection of law. Without credit, in order to obtain liquidity to meet immediate needs, small businesses must resort to sale of business assets quite often. In the case of producers, this often means sale of their livestock, sale of seed stock, equipment. In yesterday's session, we saw examples in the inter-American context. Karina explained constraints, and access to finance was the first one she mentioned, that MSMEs are perceived as high risk. And she also mentioned the importance of contracts that can add to the bank of collateral that is available. In the African context, challenges were mentioned in relation to access to finance there as well, and was mentioned that less than 5% is directed to the agricultural sector, and that is all to cash crops. So in terms of the credit needs for agriculture, there's some needs that are common across all sectors, and then some unique specifically to agricultural production. Common across all sectors is the need for short-term credit, which enables response to immediate crisis. Medium term, which enables recovery, purchase of inputs for the next production cycle. And then in the long term, enabling rebuilding resilience and taking advantage of new opportunities. I also had noted the IFAD General Counsel, as Professor Malaguti mentioned just earlier as well, example of the ABC Fund, which was provided to help those small businesses that are too big for microfinance and not yet big enough for conventional loans. So added to those challenges, which are common to most sectors, unique to agriculture is the lumpy nature of payments. At harvest is when most payments then are received. So having credit allows for some kind of transition during this period. And as COVID has illustrated as well, there's the need for timeliness in distribution, exchange, and in the value chain. Credit can be particularly important here. In terms of types of legal instruments for credit, I don't have time to go into these, but other than to mention very quickly, of course, as we know, the traditional loan against land is the banker's favorite, which is disadvantageous to women and other marginalized groups. Then we have the loan against movables, and we've seen a lot of reforms in recent years in relation to secured transactions, which enables loans against crops and livestock, other inventory. We also have the possibility of warehouse receipts financing, as Anna had mentioned. This is a work of UNIDROIT ongoing on a model law. And then we have the area of assignment of receivables and factoring. But what we need, although there appears to be diversity and there are a range of instruments, we need to consider which of these are most suitable for MSMEs. Even in the area of warehouse receipts financing, which has a lot of promise, there are challenges in structuring the instrument to make it feasible for small holders and the way that they function. For example, are they willing to commingle their crops? Does the domestic law permit a unit of shared interest in bulk goods? The conventional thinking is that improved credit for some, even the larger players, will have a trickle-down effect and result in improved credit terms for all. But we need to consider if this is indeed the case. In looking at the type of simplified legal structures that we're trying to achieve here, we can look and see that there's this range in the typology within the agro-industrial sector. There's tremendous polarity. On the one hand, highly sophisticated entities that are dominant players in the global value chain. And on the other hand, millions of smallholders, as we heard yesterday, are responsible for 80% of global food production. And so in that search for something in between, we need to find some way to bridge that divide and that supports family farms, but also enables them to climb up the value chain. And several presentations have been made that prompted reflection, especially in the context of the forthcoming UN Food Systems Summit this fall. I think that the terms of integration and diversity really spring to mind. We already know that we cannot design law in silos. Lorenzo Catolo yesterday mentioned that process is as important as content of the contract. Carmen Boulon from FAO mentioned that contracts do not exist in a vacuum. We need to consider the domestic legal context. And she gave the example of the EU farm to fork strategy, more of a broad and holistic approach. Axel Marx mentioned the VSS, the voluntary sustainable systems and private labels, which have the double-edged sword. On the one hand, a way to encourage good agricultural practices and introduce environmental standards that may be lacking in domestic legislation. But on the other hand, these stringent requirements can preclude smaller farmers. There are some examples there where Global Gap, for example, has made it possible for group certification. And then we have the example from Jennifer Baer yesterday as well of the positive illustration with the Fair Food Program, an example of buyer-driven governance. So as presented in this first session this morning, there are actually quite a range of different kinds of structures that are available. And as mentioned also with new technology, this will bring with it new possibilities. I think we also need to take into consider here the phenomenon of urban and peri-urban agriculture, which is growing in the face of growing urbanization. And that is something to take into consideration as we move forward. So in summary, then, it seems that we are really at a crossroads here, and we have an opportunity to rethink food systems, an opportunity to rethink the legal structures also. What kind of food systems do we want? And then what kind of legal structures will support this? And then in any case, I think that my synopsis will remain valid, that some form of legal structure is a prerequisite to credit. So I hope that that has given us an introduction to the other speakers who are going to go into a little bit more depth into credit instruments. Thank you very much. I return the floor.
Thank you very much, Zanette, for indeed an introduction and setting the scene, for mentioning the role of the structure of enterprising, and in particular the need for a formal structure, but also for simplification and the work of your organization. And then also the fact that this project is the means to an end, and one of the possible is to improve access to resources. There are many other things that you have mentioned, but I would perhaps go back to our panelists and introduce the second one, Christopher Brett. Christopher Brett was appointed as the lead agribusiness specialist with the World Bank in 2016 and joined the Agriculture and Food Global Agricultural Practice in Washington, D.C. He has more than 30 years experience of working within the public, private and voluntary sectors in different parts of the world, Africa, Asia, and Latin America. And the title of his presentation is Maximizing Finance for Development. So Christopher, you have the floor.
No, thank you very much, and greetings to everybody. It's been really fascinating to hear a lot about the framing around this discussion. I'm very, very thankful to Zanette, who gave us a really, really good overview. And you've taken some of my comments away already, so I can be even briefer. So thank you very much for that. Yeah, at the World Bank, just to sort of put things in perspective, we have an agriculture and food global portfolio of about $20 to $21 billion currently with our clients. You know, and who are our clients? The government. So 21 billion sounds like a huge amount of money, but I'm going to try and put that sort of in perspective of the problem. We also have the IFC, the International Finance Corporation, which many of you are aware of, which invests in the private sector, and their agribusiness portfolio of investment is around about $5 billion, $6 billion, that kind of range. But of course, around this, there's lots of other instruments, you know, in terms of the supply chain finance that the IFC does to support and put liquidity and cash into these systems. And also, in terms of the World Bank, from my side, an awful lot of work with our trust funds, which are very specific on programs. So there is a scalable points here. But, on the flip side of this, we've done a lot of analysis, over the last 2 years, and we're really building up for this Food Systems Summit 2030 on really, trying to explain where we need to have strong transformational change. And as we come out of the COVID crisis, we really, really are struggling, at this very, very small MSME sector, smallholder farmers and so on. So I want to sort of give us sort of headlines of thoughts. There was a survey done by the World Business Council for Sustainable Development about 4 or 5 years ago, looking at really smallholder farmers and how they are integrated. And I think that word that has been used is so important, integration. Integration out of this 500 million smallholders only comes to, believe it or not, about sort of 8 to 10% of those farmers are integrated into the markets. Now, if you say, what does that mean? That means that they are growing on a system where they've got a guaranteed off-taker. Now, the problem with this whole system, it tends to fall into the cash crop space. There's off-takers who want your cocoa, your coffee, your cashew, et cetera, et cetera. But the integration of food supply chains is considerably less. Now, this kind of integration that's happening really does in some ways helps this issue between formality and informality, because a lot of the companies that are integrating to the smallholders, your Olam, your Ecom, your Barry Callebaut, your Cargill, they're supporting cooperatives and producer organizations, which could be registered, but they're not complete legal entities as we would like to see going forward. So it does come into the agreements aren't contractual, they're more sort of a social compact. They're more of a business relationship based on trust and, we support you, you support us with your product. So that's one area we see growth. But what I wanted to sort of explain that I'm very worried about, in the last 12 to 18 months, there's been a huge amount of scaled commercial capital leave the agribusiness sector. Why? It's because of the huge fluctuation in commodity pricing. The risk factor has gone up. There's a lot of weak returns to a lot of investors in the agribusiness sector. So this also does have a trickle-down effect of how that money gets down to the, the SME and the MSMEs. So this is something, is showing a lot of concern, and we see that concern being translated more to requests for development finance, to the private sector development finance to governments. So out of this $20 billion portfolio, about 40%, if you analyze it, goes into value chain development. What is value chain development? That's working, in poultry, it's working in fruit, vegetables, it's working across various supply chains, which is increasingly bringing production to domestic markets. And I do stress that it's the domestic market integration, which is really important now, bringing this access to, nutritious food, not just food, but nutritious food, which is safe as well to the consumers in these hugely growing markets. Now, when you analyze agriculture, agribusiness, you start thinking, no, surely this must be a private sector activity. But as all you guys on the, all our participants or attendees know, that the government has an incredibly strong role in this private sector activity across the world. In our last analysis, we see $500 to $550 billion a year going into propping up, supporting agriculture, agribusiness. I do stress $550 billion. My $20 billion portfolio, put it in perspective, it's not much to incentivize or leverage, to incentivize these governments to look at this word repurposing. Repurposing is taking this money and put it into much more stronger incentives for change, transformation. Incentives for change, looking at the weak approach we have to environmental management. Only 1% of government money really is trying to change and support environmental change. That is just absolutely shocking when we look at this whole role of climate change, etc. I won't go into the lecture mode about all of this. We're all very aware. So I'm saying that we're working now strongly with governments on really advising them to change and shift on where they are putting their money. This is about MFD, maximizing finance for development. It's creating more space for the private sector. It's getting governments to put funding, put finance into research, development, climate smart agriculture, new technologies, away from this traditional approach, which is basically reducing, and eliminate, harming our environmental approach, number one, but also, it's not really strengthening a lot of approach to the social aspects that we're expecting of agriculture, i.e. improved labor conditions. There's a huge concern there. There's an increasing child labor coming out of COVID. There's a lot of government laws and regulations. They're not being enforced, et cetera, et cetera. So we got those bigger picture, thoughts there. At the World Bank, we're doing a lot of what we call payment for results lending, P4Rs. This is to incentivize policy change, which I think is really important to this group. Policy and regulations. How do we move government policy regulations to not just create space for the private sector, but to put a lot more enforcement in areas of concern around the social side, labor abuses, et cetera, et cetera. So we got the P4R model. We do a lot of what we call the DPOs, development policy objectives, where we work with governments very, very focused on changing policies that have a development objective. This could be related to standards in products, like, for example, we're doing a DPO in Côte d'Ivoire around cocoa, for example, to create standards around cocoa, environmental, social standards, and help to repurpose where the government should put in their funding. So, what was also mentioned a lot about the warehouse receipt models, the bank's been a big backer of that. We've been trying to put a lot of finance and liquidity into systems against collateral. We're also looking at setting up de-risking models more with local banks so that they can on-lend to small, medium enterprises. I'm not going to go into that scope because I know a lot of my colleagues and panelists here will be going into that area. So I just want to say that we're very much aware and we're very supportive. We build a lot of collaborations on that. The other thing, for me to sort of close off, I'd like us to sort of share a vision of what is agriculture, what is farming of the future. Farming of the future is farmers being paid for a good quality product at competitive market prices. That's number one. But number two, they need to be getting an income off their environmental and social management of what they do. We strongly are backing and looking now at environmental services payment. It's happening in the US, it's happening in Europe. We've got a lot of methodologies around developing agroforestry systems, which we've been doing in West Africa and other places where we're now actually paying out, against payment for results on, incentivizing smallholders to change their land practices, working with large-scale companies who integrate with those farmers in the cocoa, the coffee, etc. So there is new ways of developing finance. Now that finance is a very, very good, attractive, obviously, form of payment to farmers to change and incentivize, but also it can help them on the road to formality, which I was listening to strongly. Our biggest concern is actually getting these farmer groups not just registered, but bringing around their governance, bringing around their systems, get them institutionalized, into various methods. But there is a lot of disincentives if you're an SME to actually formalize. It does come down to tax. It comes down to transparency, scrutiny, etc. So I think we all share that real common goal is how do we move the needle on that? And that's a huge challenge. And obviously we're looking very much in that area. So I also wanted to acknowledge, we do a lot of work on the EBA, the Enabling Business of Agriculture, that was mentioned by Zanette. That's a very, very important program. Benchmarking, showing people or showing governments, showing civil society, private sector, what is going right, what is going wrong in governments, and how we can really promote and push for change. So I'm going to stop there. I think I've said a lot, the bigger picture, some of the detail on what we do and what is a future vision. The future vision for us is really very strongly about a healthy economy, healthy planet, and healthy people. That's our message from the agriculture and food practice. So I'll hand back to you, Anna. Thank you so much.
Thank you, Christopher. I particularly appreciate the fact that you linked in a way, the regulatory and governmental regulation on the one hand, governmental funding and the role of governmental funding as not as opposed to private funding, but in a way integrated into private funding, and in creating more space, as you said, for private funding, but without undervaluing the possible role of public money in reaching certain objectives. And in a way, if I understand well, but this might be a question then for you later on, is a way of creating incentives and achieving certain goals like food safety, environmental concerns, and so on, through new modalities of financing that create these incentives. Let me now maybe stop here, and because we would like to develop these thoughts during the discussion. The only thing I wanted to mention, because both of our speakers mentioned it, is the Food System Summit. I think it's an important forum for discussion that will come up very soon, and then we go now to our third speaker, Massimo Pera. Massimo Pera works at FAO as an agribusiness investment officer. He's in charge for the coordination of the project AgriInvest, enabling inclusive and efficient private sector investment in agri-food systems. And for the past 14 years, he has been working in the formulation and implementation of projects related to agricultural finance and value chains development, with a particular focus on Africa and African countries. So the title is Digital Technologies to Address Challenges in Accessing Finance for Agri SMEs. So right on the topic of innovation, innovative thoughts. Massimo, you have the floor.
Okay, thank you very much, and thanks everybody. Good morning and good afternoon, wherever you are. Basically, you know, so many things have already been said. Probably also yesterday I wasn't there, so I might kind of reiterate them eventually. But as you know, agriculture and the agricultural sector and the agribusiness sector specifically is one of the most difficult ones to invest on and to finance. And why is that? I mean, compared to other sectors, and why is that? First of all, because of the risks, actual risks and perceived risks, and we'll talk about that. But basically, because it's one of the sectors most exposed to risks, right? And another reason is that against those risks, the majority of the potential clients for these investments, bondholders, agri SMEs, and so on, don't have guarantees to use against this risk, right? So they lack collateral, they lack any kind of possible guarantees. The investing in agriculture is very expensive, especially in developing countries where you have to reach clients that live in remote areas, dispersed areas. So the transaction costs are very high, and so you see, and all these are barriers that the investors and the financial institutions see as sometimes not unavoidable, and so they tend to shy away. But those who suffer the most, I think it's been mentioned here and there, is the so-called missing middle, right? Because it's with missing middle we intend that segment of the agricultural universe, let's say, or farmers that are not too small to fall within the offer of the microfinance institution and of financial inclusions, but are not too big and large and commercial to be a client of a bank. So, and this is where the majority of small and medium enterprises fall within. And we're talking about a vast majority of those who produce foods, you know, especially in view of the Food System Summit that's been mentioned. They are at the center of these systems. Now, and just to give you a picture, there are researches that shows that there's an annual lending gap of about 100 billion only to SMEs only in Sub-Saharan Africa. So you see, all of these challenges are on the demand side, on the farmer side, on the SME side. But actually, the reason why the provision of financing is so limited is because of one key word, which is information, lack of information. Financial institutions and investors don't have an intelligence unit which understands agricultural markets, don't understand their trends. They cannot identify investment opportunities. And this is why I was talking about perceived risks sometimes. They don't have the instruments to actually weigh those risks, understand those risks, and read behind, what's perceived. And this leads to an untapped universe of opportunities to invest that is left behind because again, apparently there is no condition for investing there. Because this information are hidden sometimes, you know, and this is why up to today, the majority of financing that's gone to agriculture was from the same actors of the value chains, was from non-institutional providers, right? Processing companies, buyers, input suppliers, you name them, because they had those information. What's been happening in the past years is that information are now more and more available. And how is that? Through technology information, right? Information technology. Through let's say the revolution that's taking place through these new delivery channels that helps lenders to access data very quickly and actually access a vast, let's say, availability of data, right? And this is transforming this landscape completely. If I had to have this chat with you 20 years ago, I would say, you know, we lack information. That's it. But today the situation is different. You know, and I cannot take China as an example because China is quite unique, you know, in the way it has developed digital financial services. I mean, even the smallest petty trader in the most remote village in China would ask you to pay to her with your mobile phone, right? But anyway, this is spreading in every country, and what's happening is that there is more and more access to data about the agricultural sector, including behavioral data through the participation to social networks and so on, value chain data, geospatial data, and you know, and also trading data, you know. So with all of this big data, it's much more possible to dramatically reduce those costs and so overcome those barriers, because you can run all those data pretty quickly, and that helps you appraising the request for a loan or appraising making smoother the due diligence process of an investor. And basically, what this leads to is to a plethora of fintech companies today. So companies that provide financial services using information technology and using digital channels to deliver them, and also to a very quick increase in the provision of e-commerce services. So agricultural is e-commerce, which is the buying and selling of agricultural products online, basically can address these inefficiencies in the agricultural supply chain. Because as you know, another reason why it's very invest in value chains is because they are so disaggregated. There's no coordination through them. There's a lack of governance. But e-commerce can actually streamline farmers' access to customer, because now smallholders, SMEs, they can sell directly to their clients, retailers, consumers, through these platforms. And this can help generating fairer incomes and help developing a transaction history for farmers. And it's interesting to see that the number of agri-commerce platforms in low middle income countries has grown exponentially. We have data, the GSMA data from 2009 shows that there were some 126 e-commerce platforms in the world back then. 6 in low-income developing countries in 2009, 126 in 2019, and 17 of them are in sub-Saharan Africa. So this the provision of this kind of services is growing really exponentially, and you know, even the e-commerce platform per se, you know, they can even decide to partner with the financial services providers to make sure that its clients have access to financial services for you know, working capital and for investing, so that they can increase the volumes of their trade in their platforms. But at the same time, if they don't find partners interested in that, the platforms themselves becomes providers of financial services. So this is the overall picture. There's no time here to give examples. I would love to, numbers, pictures, figures, and so on. But again, and I think who's speaking after me is going to talk about this as well. I mean, it's taken an incredible room in the space of agricultural finance. Having said that, I'd like to close with some questions to ask to the specific subject of this webinar, which is all of this is very interesting, but there are cons. It's not only about pros, and one of them is that, of course, there's a risk that the financial gap increases in developing countries for two main reasons. One is that these new financial services providers are very aggressive in penetrating these markets, and there is a risk that they crowd out those institutions that were actually serving and try to increase the outreach of their, of their supply of financial services to smallholders, right? So if they're crowded out, then the risk is that this fintech services, for example, only goes to those who can use a smartphone, who can use a device, and can interact with the interface of the services. So that's the first thing. The other thing is that all this revolution that's taken place from a digital perspective still brings some concerns with it, because, and it's not only about agriculture, it's everywhere, but who owns the data? Because the access to this data generates a lot of information about people. But, and I'd like to pose a question maybe for discussion, how to regulate that? How to regulate the use of data? How to regulate the markets and the presence in the markets of these actors? Kenya was one of the first countries where mobile payments took place some 20 years ago. They found out it could be much more efficient to send money through an SMS. But that grown so quickly that there was the need to regulate the system came immediately, and it took time for the Kenyan authorities to regulate it. And still, it's a long process. So these are the main issues. I think that this on one side, again, I'm trying to send this message. Greatest opportunities to reduce the gap, greatest opportunities to reduce the costs. But on the other side, some risks that are of increasing the financing gap and the financing divide. I hope this helped informing the discussions, and I look forward for the Q&A and the further discussion. Thank you very much.
Thank you very much, Massimo. Thank you particularly for underlining, as other speakers have underlined, the fact that we are talking about a risky market, how difficult it is to invest in this market sometimes, and focusing on information and informational gaps as one of the key issues. So we can see how this can link to the way enterprises talk to each other, or the structure of the enterprises, and also to highlight the possible risks, digital gap, and the need to regulate technology, which is not only in this sector. So I would like then to give the floor to our fourth speaker. Dagmari Habte-Selassie is a sustainable development professional with extensive experience in structuring financial vehicles. So to fill in specific gaps in the agribusiness financial ecosystem, he is working with IFAD, currently working in Uganda and leading their engagement there with private sector and rural finance institutions. And I think the title of his presentation refers to this experience, and he will explain what is blended finance for agri-SMEs development, giving the example from Uganda. So Dagmari, you have the floor.
Thank you very much, Anna, and thank you, colleagues at UNIDROIT, for having me today. I hope I'm very audible. And also, thanks to my colleagues, my panelists, that have set the scene quite ably for me to come in and dive deeper into a specific example that we have in Uganda. I have a presentation to give a bit more color into what I'll be saying, so I'll share that. But while I do, for those of you who are familiar with IFAD, it's the International Fund for Agricultural Development, and the way IFAD works is mostly through loans and grants to government. So we've been existing for 40 years, and we focus on really building capacity of smallholder farmers by building capacity to increase productivity, production, rural infrastructures, access to finance. And over the past, I'll say 5 to 7 years, we've seen that as we go into this value chain approach that Chris has touched on, that there was still a sizable gap, that the rural SME space was not vibrant enough. And although you're building capacity of your smallholder farmers, the off-taker wasn't always there. And we went and looked into what are some of the critical gaps that they had in terms of financing, in terms of capacity. And more and more IFAD now is turning into having a private sector arm, which we're able to approve last year on our board. And the presentation I'll do today is on the Yield Uganda Fund, which was a precursor to the ABC Fund that was mentioned before, but also to our private sector engagement that we have in Uganda. And this was something that was developed in partnership with the European Union. So I'll just take you through it. So the Yield Fund is really investing in agri-SMEs. We invest 250,000 to 2 million in SMEs in the rural space in Uganda. And why SMEs? What's the importance of SMEs? There's just a little slide to set the scene to show the importance they play in the African continent. 90% of SMEs, businesses are SMEs in sub-Saharan Africa. You can see the comparisons with the US and Europe, but more importantly, they have 60 to 80% of the job on the continent. And Africa, as you all know, is a very young population, huge youth, burgeoning youth population, and more countries are struggling with job creation and how they're able to sustainably create jobs for the youth that come in on board. And SMEs will play a vital role in addressing that. And since I'm focusing on Uganda, and I'm not sure all of you are familiar, I'll give you a bit of background on Uganda. I won't go into detail into all of these different aspects, but maybe why agriculture and why Uganda. Agriculture, massive part of Ugandan economy, employs 70% of the population and 24% of GDP. But I think as challenges in most African countries, and we have the government expenditure towards agriculture is at 4%, even a bit lower last year, which is way below the 10% that under the Malabo conference, and way below the needs of the sector in general. And the SMEs, just to paint a picture of what an SME has to go through in Uganda. If you're looking for a loan as an SME, you're looking at 20 to 25% interest. Your terms that you'll have is 2 to 3 years on 120% collateral will be needed to do that. So just imagine as a company, a startup trying to make it in the space, if you borrow money, you'll have to make, over 30% a year to be able to be profitable over the next 2 years. And a lot of, the businesses in the West are privileged not to have those burgeoning debts and payments, cash going on their business. They're not able to fuel expansion. And that's a major challenge. And specifically in Uganda, I think private sector credit is quite low. A lot of it goes to government. Government takes a lot of the money out of the system to fund their work. And we're looking at about 14%, even compared to the 28% that we have in Kenya as a neighbor, or 50% that you'll see in India. And out of that 14%, only 13% goes to agriculture. So just that paints a picture of the challenges an agri-SME faces in Uganda coming. So the Yield Uganda Fund is a partnership. These are all the different partners that came together with the fund. I'll highlight maybe 3 key partners. The EU was a co-creator of the fund with IFAD, so they're a key partner and a key financier. We have NSSF, which was a big hit for us. NSSF is the National Social Security Fund of Uganda. So local pension funds hold a lot of capital in these African countries, especially in sub-Saharan Africa. But they're not finding the right vehicles to be able to invest in agriculture. A lot of it has gone to infrastructures and telecom companies, and most of the time, on vehicles. And for us to be able to attract an investor like an SSF was quite important. And we have PCP, Pearl Capital Partners. That's our fund manager, and the fund manager is based in Uganda. It's a local fund manager in Uganda managing the fund, which is a big added value compared to other fund managers. They'll have to fly in, fly out. They have a deep understanding of the sector, of the country, and are able to provide the handhold and support some of our smaller SMEs need, and also a good knowledge of the country, which you wouldn't necessarily not have if you're not residing in the country that you're investing in. And so how does the yield fund work? We have two tools for the yield fund. First, on the right-hand side, my right-hand side, I think yours as well, we have the fund itself, which is managed by Pearl, and that invests in companies. We have a 20 million euro fund. The EU IFAD through the EU has 10 million, invested 10 million there, and was able to get 10 million from other investors. And our 10 million, talking about incentives to get other investors coming in, is a first loss, which means that for us to get our money back, everybody else needs to make their money back to be able to invest. And we took that stance because of the high risk of having a single country, single sector fund, but also, and to be able to attract investors that will necessarily shy away from these type of structure. And we offer debt, equity, and quasi-equity, very patient capital, a lot more patient that they will have in the market elsewhere. And in addition to the fund on the left-hand side, the BDS facilities managed by IFAD, it's a facility which is about 2.5 million facility, which supports companies in key capacity gaps that they have. We invest, as I said earlier, companies between 250 and 2 million. And we have companies that are quite early stage. They're not as mature. For example, we have a company that has one bank account to manage all the company aspects, also the family business and the school fees and the vacations all into one, and putting those governance system in place. A lot of investors will shy away from this type of complexity because of all the work that's necessary, but we have a facility to help us really support them in areas of governance and social and environment, ESG in general, where I think about 60 to 70% of our money goes towards ESG items from the BDS, but also we help them in operations and marketing, whatever the gap is for the companies to be able to grow. That's how we invest. So just to progress to date on the fund, we have 9 approved deals, about 8.5 million euros committed. What we've seen is, although you would think that equity would be, as an SME, you would want that patient equity capital. There's still a lot of reluctance, especially from our smaller SMEs, to wanting to give up shares of a company. They see this as a bit more of a, relinquishing control of their business. So we, due to the flexibility of the fund, we're able to have a mix of everything, including equity and quasi-equity. And one thing that we've seen with COVID is it's quite challenging for some of our companies, but we're seeing a lot more companies interested in impact money now. So it's a bit out there. I think there's been good stories that came out from some of our SMEs, and our companies have become our ambassadors of sorts of showing what's there. So we're seeing a bulging pipeline, at least on our side for that. And the BDS, I talked a bit about it. And one thing that we had to do over the years is really, we came in with an idea of how a company will want to have that type of support. But over the years, we've had so many changes, updates, recalibrating. It's a cost sharing facility, but we want to make sure that the SMEs are handling all aspects of it. And we made, I think, 6 or 7 different changes in 3 to 4 years in the BDS to ensure that it's able to respond to those farmers. And the type of companies that we look at are really smallholder inclusive, mostly. So we have a very heavy impact assessment framework where we go for ex ante quantitative analysis mixed with a post quantitative and qualitative analysis. We've done 2 baselines that were quite, that gave us quite an insight of what the farmers linked to those companies are doing and what other challenges they're facing. And that was able to actually support SMEs to better understand how they can serve those and secure their supply chains. And as of now, the companies, we have about over 5,000 farmers and 285 additional jobs expected to be created actually in the next 3 years or so from the companies that we've invested in. Just to give you a bit of color in what these SMEs are, so we're very keen on smallholder inclusive value chain. So Raintree Farms, the one at the bottom, is a Moringa company that works with smallholder farmers in Western Uganda and really has an interesting model of paying them a salary. They have a secured income plan for all their farmers. So they pay them a monthly salary thinking, we'll pick your leaves when they're ready, your Moringa leaves, but we're going to pay you a salary. So to really help them manage a bit more their budgets, I think colleagues were talking earlier about, the big lump sums that come in and all the different needs that come into a smallholder farmer. So they're utilizing a model, and that was very well appreciated, especially in these times from these farmers. And that's something we're looking to learn on how that model affects more, how other farmers are being, how this is impacting their lives compared to other farmers that get the one lump sum and have all these major bills to pay. A Pristine Food is a processor, and most of our companies will fall under the Pristine Food model, processing companies. They do liquid eggs, which is very new. There's only a few companies in whole sub-Saharan Africa, liquid and powder eggs, and they were actually quite good. They were a startup. We invested in them before anything was there, so built the factory and everything else. And during COVID, they rose to fame because they're the only company being able to buy eggs with the lockdowns and everything that happened. So a lot of poultry farmers, which are quite strong here in Uganda, were keen to bring the name and the presidents. And so they've become a more of a household name in a year and a half due to the key strategic role they played around the poultry value chain. And also Chemifa is an interesting one. This is not really related to smallholder farmers, but they play a very ecosystem facilitating role. They're an accredited lab. Uganda, for your information, is in the top 5 in terms of food rejections at EU borders. So not meeting the EU minimum requirements in terms of quality standards for exports, especially fresh fruit and vegetables. So Chemifa has a massive role to play there. So we've supported them in upgrading their capacity and also different areas to really support the whole ecosystem of SMEs, not just the yield fund ones, which are using Chemifa, but other ones to be able to do that. I think just to touch on, other than that, so the yield fund is really part of the EU IFAD portfolio, but the EU, this is a small part of a bigger EU plan to support capital markets and access to credit in Uganda. And we're very keen to have this lesson. It's the only registered fund in Uganda as of now. We're the ones that have taken that deep dive, saying we need to go there and we need to use our experience to really affect changes to be able to drive more private credit for SMEs in Uganda. So we're quite active in a lot of the ecosystem building. So in all of the private sector and agriculture working groups of the government and development partners. Key members of the East African Venture Capital Association, which is really trying to build that ecosystem around how do we get more financing into that. We also do a lot with SAFIN and Impact of Africa, which are global networks looking to drive that. And one thing we're keen to do, in addition to our impact assessment, to really understand the impact pathways of this impact investment, how does impact investment really lead into change in smallholder livelihoods. We're doing a few policy papers. We're just finalizing one as we speak on the challenges of domiciling and funding Uganda. As I mentioned earlier, we're the only one registered here. A lot of people prefer to be registered in Mauritius, even Kenya or Luxembourg, obviously for tax benefits. But we're doing an assessment of what are the key gaps and working with the government to see how we can tweak a few of those to get more funds domiciled here, especially as East Africa is becoming a big area for impact investing. but also on the institutional gaps for SME development. There's a few things, especially on the capacity of SMEs and how incubators and the relationship between incubators and impact investors and the gaps are there, and how we can better support this capacity building of SMEs as they go along the value chain of investment. And yeah, that's it in my conversation. So thank you very much for your time.
Thank you, Doug Maui. Thank you for giving us very practical information and empirical data on the challenges to access finance for smaller businesses in a specific region, in a specific country, and also an example of a project fostering private sector funding, creating a specific vehicle, and trying, however, also to support the lack of knowledge and sometimes also maybe other needs for help of smaller enterprises. So I am conscious of the time. I would like to take many questions if possible, and so let's go to our last speaker, who is Isabelle Deschamps. She I don't see her.
Anna, did you want to have me go too?
Oh, I'm sorry. No, it's my fault. I'm very sorry. I'm very sorry. I take the responsibility of the chair to have given the floor to the last speaker, but we still have a very interesting presentation by Steven Noka, who also will talk about a very practical experience. He's a founding partner of a fintech startup now based in Singapore, with application for SMEs in the developing world that will launch in the second part of 2021. But previously, he was involved in lending at Root Capital, an NGO dedicated to agricultural finance in the developing world. So he has experience to share with us. And the title of his presentation is Challenges of Lending to Smallholder Agricultural SMEs. So sorry again, Stephen, you have the floor. It's your moment. Thank you.
No worry, Anna. People are always forgetting about me. Good morning and good afternoon, everybody. Again, my name is Steve Noka. I'm based in Boston, where it has been snowing all morning long while this has been going on, very, very sadly. As was mentioned, we're launching a new fintech startup focused on SMEs. Might not see the connection between the topic of this forum and what I'm doing now, but as Anna mentioned as well, spent a couple of years at Root Capital, which is an NGO lending to the so-called missing middle agricultural SMEs in developing markets, frontier developing markets, Latin America, South and Central, Sub-Saharan Africa, and in Southeast Asia. I led the restructure of the business from 2018 through 2020. It was a failing lender. It is now launched, very focused. Prior to that, I spent 25 years at Bank of America, where I oversaw the whole trade finance business. You know, one of the interesting things that we heard a few minutes ago from Christopher, the World Bank, is that his fund, they've got 25 billion focused on agricultural sector. My portfolio at Bank of America was the same size. So I put that not to say, wow, we were so big, but to really say those numbers are really relatively small, and they don't really go very far. When you think about trade in Africa, it's roughly $1 trillion number pre-pandemic. That's just, again, one continent, which is relatively small in terms of trade flows, just showing whether it's private sector or public sector that there's a need for much more money. I will keep my comments relatively brief. I view my role here as more of a practitioner, one who's worked across developed and developing markets, both early, late stage, cash export value chains, as well as local value chains, many different types of corporate entities, from cooperatives, associations in place, particularly in Latin America, local corporations to the multinationals. I can talk for hours, but again, I will try to be very brief. In summary, I sort of think about the three buckets of challenges that we face in this sector. How to provide a loan successfully to a SME in the developing markets in agriculture. It's high risk. There's no higher risk profile from a banker's perspective. Secondly, it's a relatively unattractive sector. And I'll talk a little bit about that. But it's just, it's in a zero-sum world. In my $25 billion portfolio at Bank of America, or my let's call it $100 million portfolio at Root, there are an endless number of opportunities, and there's competition for that capital. This is a relatively unattractive one. The third challenge is one that we just heard about in terms of blended capital. And Dagmari sort of spoke about sort of the intersection of banks and supranational national governments and a lot of foundations, sort of combining forces. It is a blessing, and it's a huge curse as well. And we'll talk a little bit about that. But that, roughly speaking, is sort of how I characterize this landscape. Just jumping into the risk side, again, this should all be fairly understandable and straightforward. I sort of refer to the risk side as the trifecta. It's developing markets. Why are developing markets challenging? Again, there's so many obvious reasons, but just to bring out a couple of them that you might not think about. Currency. It's really hard dealing with currencies in places like Tanzania, for instance. You can lend money in, but good luck ever getting that money out of the country if you're an offshore lender or even onshore. The convertibility issues are maddening. And then one of the the big topic here for over the last 2 days, the legal systems. I can talk, go through any number of different war stories from my Root Capital days. And I'm looking at Dagmari on the screen here, in a couple in particular in Uganda. Well-structured loan. We took collateral. We had both land as well as equipment, and we were lending against inventory, so we had a floating lien on that as well. 5 years later, we've gone through bankruptcy. The judge has found in our favor. We had nothing to show for it. We did have some death threats from the borrowers, and so it just that you can kid yourself into thinking that you have collateral, you have a well-structured loan, but good luck ever realizing on that loan. And again, I picked on Uganda. I could equally have gone to Peru, Colombia. We've had some wonderful stories there as well, as you might imagine. So again, this just runs throughout the sector. Secondly, commodities. Everything that we were doing at Root, and most of what I was doing at Bank of America, was involved with commodities. Commodities are fine. For the most part, they're you can look at exchanges. I can open up the Wall Street Journal or the FT and look at the price of cotton, coffee, whatever it may be. But there's extreme volatility. And so when you're making a loan against for coffee that's being shipped from Rwanda to a buyer in the US or Europe, it's fine. But ultimately the price when it leaves the farm to the price when Starbucks takes delivery of it will vary widely, and that affects every step along the chain. You can hedge, you can do all sorts of things, but typically our smallholder farmers and the cooperatives or other, the SME is limited in their ability to hedge that. So it's difficult. Third, agriculture. Again, I won't spend any time on this to speak of, but ultimately, you've got weather, you've got climate change, you've got the logistical challenge. Just imagine for a moment, I use the example of coffee from Rwanda. It's an amazing market. I'm always just in awe of some of my old clients that were cooperatives that were purchasing coffee from smallholder farmers, somewhere 100 miles in any distance from Kigali, processing that coffee locally, putting it on trucks, shipping it across the border through either Kenya or through Tanzania. Sometimes you have to go through Uganda too, depending upon the border closures. Ultimately, then going through a couple of different countries, ultimately getting to either Mombasa or Dar es Salaam, going into storage, waiting for the ships to arrive, putting them in bigger containers, and then going somewhere around the world. Throw on top of that COVID-19 and the restrictions crossing any border. And what's amazing to me is that the coffee, it still arrives, and we're still able to drink it, but the logistical challenges of getting that from point A all the way to point Z is daunting. And there are very few other value chains that have, these same logistical challenges. The distances are long and they're really complicated. It's the trifecta. I mean, again, they're from a lender's perspective, there's no riskier sector. Next up, why is this the ugly stepchild? Why is it so unattractive? It has, when again, breaking it down into the basic categories that a banker looks at it from a pricing standpoint, it's actually pretty good. If you're lending in local currency back to Uganda, I can probably charge 25%. When we were lending in Ghana, a lot of the loans in local currencies, 25%. Again, take the ethics and the morality out of the picture. That's a pretty darn attractive rate when you think about where the US dollar and euro rates are these days in negative territory. It's a significant spread. So that's not really the issue. The issue really is the fact that on most of the loans that we're looking at, the average loan size that we had at Root Capital, which is pretty consistent across the SME space, agri SME space, was anywhere between $500,000 and $1 million. The loans tended to be a little bit bigger in Latin America, a little bit smaller in Sub-Saharan Africa. But from a banker's perspective, the cost to make that loan is the same, whether it's a $5 million loan, a $50 million loan, or $500,000. It's not a fixed cost, but generally speaking, you have to do the same sort of analysis to underwrite it, structure it, and to document it. The price doesn't really change all that much. And so therefore, in a world where you're making rational decisions, why would I do that $500,000 loan where I can find a $5 million loan? You're not going to find a $5 million loan in agriculture generally, but you can, if you're a bank in Nairobi, you're going to find plenty of property loans that are of that larger size. Economies of scale, you as a banker can make a lot more money finding those bigger loans, which will take you outside of agriculture. The other part of the cost situation is that most of the lenders that I was aware of in the space in agriculture were not the traditional banks, because they were making rational decisions. They were making those $5 million loans. And also, particularly in Africa, you find that the local banks have spent a lot of their money buying government bonds. They're safer, good yield, and they tend not to be in agriculture. So you tend to find a lot of the non-traditional lenders. You find social lenders like Root Capital. You find quasi-governmental organizations making those loans as well. So the reason why this is relevant is that they tend not to have scale. They tend not to be the most efficient. And so again, the costs are higher. Just to break it down into dollars and cents so you can understand what this looks like. If you're making a $500,000 loan in agriculture to a cooperative in Rwanda, I'm going to charge, because it's US dollar, you're not charging 25%, you're actually charging about 10%, which is kind of the going rate, whether it's dollar, euro, sterling. What we heard from Zanette mentioned earlier has sort of the payments are lumpy because you have your typical borrower is not borrowing for 12 months, they're borrowing for 6 months because they're borrowing so they can purchase the coffee from the farmers, and then the money is flow back in. So the average tenor is probably 6 months. So if you have a $500,000 loan at 10% for 6 months, that's net interest income of $25,000. Round numbers. The average cost per loan among the social lenders is roughly $35,000. So before you've written off any loan, before you've done other things, you're already losing money from a banker's perspective. It's unattractive. The third point, which might be controversial with some, is about blended capital. As I said earlier, it's a blessing and it's a curse. If you look at that issue that I just raised for that $500,000 loan, I'm missing $10,000. How can I stay in business as a lender if I'm losing $10,000 on every single loan? Well, you can't unless somebody's going to help pay for it. When I was at Root, we were very successful in working with a lot of foundations who wanted to make an impact and were willing to help subsidize that loan. And many were also willing to help backstop the loans, guarantee the loans, and so on and so forth. But the bigger issue was not, the bigger issue really was the subsidy required to make these smaller loans. Again, if I'd made $1 million loan, I would probably be okay. But that $500,000 number it's just too small to make things work. So the part of the issue again, the blessing is easy to see. People, foundations, governments are willing to help support these lending operations. The curse comes in that when somebody's paying to subsidize that $10,000 that I need, I'm probably not having my team spend as much time as they could to figure out how to lower the cost of that loan. How to back to Massimo's presentation around some of the fintech enablement. I mean, that's all about lowering costs. There's a piece that's also about making smarter decisions, but it really is about lowering the cost of making that loan. And if I can lower that cost from 35 to 20, and that should be pretty easy and straightforward. But the real promise is to get that down to $15,000 or even $10,000 per loan, which you can do. So that's part of the issue. The other part of the curse is that when you look at a lot of the social lenders that are engaged around this space, they're massive fundraisers because they have to be. And fundraising becomes as big a part of the business as is the lending. And again, many of the organizations don't want to admit it, but ultimately that kind of becomes the game. So it's a real challenge, and the question is whether you actually ever can be sustainable. The final point, and I've really sort of covered this already, is that what we need to figure out how to do are a couple of things. I haven't spoken too much about the risk side of things, but when we were at Root, we actually did succeed in reducing our default rate from what had been 20 to 25%, which is wildly unsustainable, to 2%. So we made it sustainable. We had to pick and choose what types of business to do. Part of the reason why we were as unsuccessful as we were is because we were all over the place, from a jurisdiction and from a value chain perspective. This is specialty lending. It needs to be recognized as being specialized, and you need experts who understand it, who can say, I know coffee, I know how to structure coffee, or I know avocados, and I know how we can do that. But where banks run into trouble, and these are with both proper banks as well as some of the social lenders, is recognizing the challenge, the difficulty, the risk, and building a team, building a platform to specifically understand the risks and underwrite them. Structure is a really important part. I don't think we have time to get into too much of this, but we borrowed heavily from some trade finance structures that allowed us to significantly reduce, if not de-risk, the loans that we were making, ultimately using a supply chain finance technique in which the buyer was assuming a lot of the risk that heretofore was with the SME. That's the first point. Second point, in terms of the revenue, how do you increase the revenue to make the loans more attractive? Again, I don't think you want to talk about raising interest rates. That's something that some do. Increasing utilization. There are some techniques to make this better, but ultimately the more fruitful path to make it work will be lower in costs. There's a scale piece of this. Small social lenders have a role, but they're never going to make a huge difference in a market that needs billions and billions and billions. Fintech will help. And ultimately, it's not this silver bullet. It's going to solve all the world's problems, but it will help to significantly reduce costs. And what I've discovered in my work, and I'll close on this, is that if you're sitting in a European country or sitting in the US or Canada, you are a lot less exposed to fintech than if you're sitting in sub-Saharan Africa, Southeast Asia, or Latin America, where fintech is really taken off. That's it for me. Hopefully I didn't bore too many people. And I'll turn it back to our chair.
Thank you. Thank you very much, Steve. And I'm sorry that we don't have sufficient time to develop all these thoughts, but thank you for underlining the challenges in investing in developing economies, but also in your last part in trying to find some and talk about some solutions, innovative solutions. And we would be nice to go on that and maybe to get more information from you later on this. Now, allow me very quickly to pass to our last speaker, Isabelle Deschamps, who is a doctoral candidate at the Faculty of Law of McGill University in Quebec, Canada, and her research is focused on the interaction between regional business law reform and the practices of market women in Benin, Cameroon, and Cote d'Ivoire. The title is Learning from Women's Experiences with Community-Based Financing in West and Central Africa. I think she has a very concrete example to show us. So, Isabelle, you have the floor.
Thank you very much. Good morning to some, good afternoon to others, and greetings to everyone. Before anything, I'd like to thank the team at UNIDROIT for organizing this very interesting and instructive webinar, and in particular for giving me the opportunity to participate in the discussion. I guess I have the privilege and the somewhat daunting role of being the last speaker today. So as was mentioned by Professor Veneziano, over the past years, I've been studying the interaction between commercial and business laws and the modes of organization of market women and women micro-entrepreneurs in 3 West and Central African countries. And so the intervention I will be making today is informed by this research. In this regard, the first point I would like to raise concerns the relevance for a future instrument on the legal structure of agricultural enterprises to take into account the challenges that women in particular face in accessing credit needed to produce, trade, and distribute agricultural products. More broadly, the idea is that the contemplated instrument be attentive to and responsive to the socioeconomic specificities of the numerous women whose work in countries such as the ones I conducted research in is indispensable to the agricultural production, distribution, and commercialization chains. Indeed, women play a vital but sometimes underestimated or misestimated role in these chains. So to illustrate the need to be attentive to women's specificities, I will refer to one example of such a specificity, and it concerns women's significantly lower levels of literacy in comparison to those of men in a number of countries in the world, including Benin, Cameroon, and Côte d'Ivoire. Women's low levels of literacy negatively affect their ability to seek, obtain, and properly manage credit. It also deters some from entering into collaborative working and financing arrangements. As such, it constitutes an obstacle that women must overcome to access credit, both formal and informal, and they face this obstacle more acutely than do men. Being cognizant of this is relevant for the task of elaborating an instrument on agricultural enterprises aimed at, inter alia, promoting more inclusive agricultural finance. Indeed, it is to be expected that such an instrument would make reference to, encourage, or favor the use of written agreements, terms, or rules governing the internal organization of the structure being contemplated. It may also, for instance, provide for the accomplishment of formalities for the formation of the structure or for accessing and securing finance. So all of this would require an ability to read and to write. In light of the fact that this ability is not a given for many of those working in agricultural value chains in West and Central Africa, especially for women, it may be relevant for the proposed instrument to either adopt, where possible, a flexible approach to the need for writings and formalities, to question this need when it arises, and to seek to limit the requirement for written documents where appropriate. I should say here that following Monica's talk on UNCITRAL's draft guide on limited liability organizations, that this issue was actually, the issue of written requirements was quite significantly discussed during the working group sessions. And the guide does seek, the draft guide does seek to a certain extent to limit the requirement for writing, but it also refers user states back to their national laws and legal traditions. So this being said, it might also have been possible, and this may be possible for the future instrument, to devise, use, or draw inspiration from alternative rules and mechanisms that exist and that would fulfill the policy objectives that underlie a requirement for written form, such as, for example, promoting certainty, encouraging trust, or preventing disputes, without or with limited need for writing. Practical examples of such alternative rules and mechanisms can be found in community-based financing vehicles used by women working in the agri-food value chain in West and Central Africa. So this brings me to the second point I wish to bring to the discussion today, and it concerns the insight that A better understanding of such community-based financing vehicles could provide for the task of elaborating an instrument on the legal structure of agricultural enterprises aimed at promoting more inclusive agricultural finance. Indeed, although various challenges such as illiteracy prevent or limit women agricultural workers, market traders, and micro-entrepreneurs in Benin, Côte d'Ivoire, and Cameroon from having recourse or access to bank and microcredit loans to finance their activities, they have for many decades been using other types of mechanisms for obtaining credit and saving for saving money. So one such form of alternative mechanism is community-based finance. This type of financing is widespread and is widely used in West and Central Africa by both men and women. This being said, community-based finance vehicles are likely the most accessible credit and savings vehicles for women who produce, trade, and distribute agricultural products in the region. This is why it's relevant for work on agricultural enterprises to consider the rules, the attributes, the perceived advantages and disadvantages of such mechanisms. For the time that remains, I will provide a brief overview of these elements. So first, community-based financing vehicles in West and Central Africa often take the form of rotating savings and credit associations. In the region, these vehicles are referred to in French as tontines or tontines, or reunions. They also have their equivalent names in national languages. The rules that govern them are highly binding among the members, and their complexity varies depending on the level of financial sophistication of the members, on their number, and on the objectives meant to be achieved through them. In the most basic and common tontines, members regroup periodically, sometimes weekly or monthly, and each member deposits a fixed and previously defined amount of money with the treasurer. In everyday language, the amount collectively collected is often called la cagnotte in French, or the English translation of this would be the jackpot. The jackpot is distributed on a rotating basis to each member of the tontine every time the members meet. And the jackpot, which is in fact a loan, is thus reimbursed by members through their periodic and mandatory deposits in the tontine. The term of a tontine ends when all of its members have been loaned the jackpot and have reimbursed it. Mutual trust is a vital condition for the proper functioning of tontines, and this is why membership is based on a common identity. For example, in rural Cameroon, tontines are often divided by gender and may regroup women of the same village or neighborhood, or women who all grow rice on the same or bordering plots of land. Going back to the poor literacy example or specificity I referred to earlier, the common identity that is required of members of a tontine and the mutual trust that derives from it are particularly important for members who cannot verify treasury records because of their poor ability to read, write, and keep proper counts. While the associations through which tontines take place are in a number of instances formalized by their members, tontines as a saving and credit mechanism as such are not specifically regulated by national laws. At most, one could say that the operations that some of the most sophisticated tontines carry out amount to banking or microcredit operations and should, as such, comply with the relevant legal requirements. So there's somewhat of a gray zone here. Tontines are seen by their users as having a number of advantages in comparison to formal credit providers. One obvious advantage is that they are more accessible than formal institutions, especially for the poor. They're more flexible too, in case, for example, of default, because the problem can be discussed directly with the members of can be discussed and resolved directly with the members of the tontine. Moreover, management fees are low given the small scale of the operations and because of direct management of the members. Another related advantage is that any interest or penalty collected is either redistributed amongst members at the end of the term or used for management of the tontine. Therefore, members benefit either directly or indirectly of the interest and penalties they might pay. As financing vehicles, tontines also have defects. One of these is that members that participate in a tontine are not all treated equally. Indeed, for example, the rotation of members who receive the jackpot or the loan results in some members being either creditors or debtors for longer periods of time. This disadvantage was, however, not raised to me during the interviews I conducted with the women I met during my research. This being said, a number of these women alluded to another weakness of tontines, and it concerns the lack or dysfunctional governance mechanisms which can facilitate the exploitation or abuse of more vulnerable members. I will end here my overview of how tontines work, but I hope that this has shown that examining the types, attributes, uses and misuses, as well as rules governing community-based financing mechanisms that are used by women could help design innovative and ground-informed legal solutions to overcome some of the challenges that are faced by individual agricultural workers and small agricultural collectives in accessing credit, and also by institutional and non-institutional lenders in providing this credit. More generally, I hope that I've complied with time and that my presentation has also shown the relevance for the future instrument on the legal structure of agricultural enterprises to be adopted, be elaborated with a gender-sensitive approach. So thank you very much for your time and for this opportunity. Thank you.
Thank you very much, Isabel. And indeed, we are looking for innovative ways to develop finance, and empirical examples are something that it's very important to build on. But unfortunately, we really are running out of time. We have overstepped the time that was allotted to this particular panel. I understand that there might be time maybe for one question. And I see the Secretary General's hand up. So Ignacio, you have the floor.
Thank you. Apologies. I know it's not very polite that we also give ourselves the only question, but I think it's important. Thank you all. It's been a very, very interesting session, very important. My question would be either to Christopher, to Steve Noka, or to Dagmawi, but since Dagmawi is an IFAD person, this is also his project, and I'm hopeful we can chase him any other time. So I would ask any of the World Bank representative or to Steve. Right. So some of the things we've heard about how financing is accessed are all very familiar and make a lot of sense. Currency problems, logistics issues, problems of rule of law, enforcement issues. Of course, all of that is very clear and is a big problem. But our question would really be how all of that relates to structures. when the World Bank buy lending to the banks or directly Steve's shop, when you adopt a decision to lend, do you look at the structure of the cooperative or the business, or how it's integrated? Do you look at it? What are you looking for that might, create an alarm that would prevent you from lending to them? Do you have priorities? So in terms of these structures, do you prefer contract integration? Do you prefer, a fully fledged legal entity, or a group, or a cooperative which incorporates a group? That is the question that would be very, very relevant to our project. So does this structure influence access to finance? Any of both, either one would be.
Well, thank you. Let me come in on that. I mean, that's the big bucket item of a question. But I'm going to try and be succinct. And obviously, the World Bank is very strongly governed by its environmental social framework. We have a whole range of safeguards. And those safeguards have to look very carefully at the whole process of where the funding is going. We're not talking about just the funding to the government, but where it's on lending or on financing. We obviously open credit lines to local banks, and we've been working very hard on strengthening the local banks' environmental and social governance frameworks to ensure that they have the ability to look at these opportunities. Hearing what other colleagues have said, I think, we talk about the informality of the sector, but we also have huge challenges in building an investable pipeline within the SME sector. And a lot of the work of the World Bank is actually building that pipeline for investment. And as we build that pipeline, we often are working with organizations to structurally change them. We're not in the business of excluding where the World Bank is. We're the first mover in a lot of challenging environments. 25% of our lending, for example, goes into FCVs, the fragile conflict violent states. I'm personally visiting Afghanistan regularly and working in Afghanistan. Now, I'm sure there's not much commercial finance will go rushing into Afghanistan. So we have to, really work and lay those ground rules. So we have the matching grant system, and the matching grant system is a way of putting finance often at 60% to the 60% grant to a 40% business plan, or 70%, 30%, depending on the country, the location. And out of that grant, and the funding we do, there's a lot of capacity building of government, capacity building of producer associations. We really do focus on strengthening these extension delivery services to prepare these organizations. If you look at the IFC, they've done a huge amount of work organizing smallholders. There is a manual for smallholder development that was released 2 years ago. We're currently updating that now. That manual talks about all the struggles of working and developing the producer associations and where their weaknesses are. Producer associations in certain countries have been notorious with corruption and abuse as well. Even so-called legal entity doesn't mean that their act is clean. There's got to be a lot of due diligence. There's got to be a lot of transparency and so on. I think the whole conversation around technology is helping a lot, because the technology is bringing the systems of traceability and traceability of those products to communities, or to the first point of aggregation. I think it's a very weak argument to argue traceability to the farm level, because smallholders have got such small amount of product. It's about aggregation to the community level, or the first decent point of volume. So traceability is also helping to show where the product is coming from. So if you're doing due diligence on a supply chain, which companies are doing increasingly, on the cocoa, the coffee, and so on, because of the risk of child labor or labor abuses, they want that traceability to see where the product's coming from. You identify hotspots, and those hotspots of challenges then can be worked with the government or public-private partnerships, and the bank is supporting an increasing amount of work on that. We're currently working with the FAO now on a very, very detailed work on child labor. This is the year of anti-child labor, or the year to promote awareness and concerns of child labor. And there'll be a conference that we're going to be working with FAO coming up in November in Rome. So yes, you're right. The areas are challenging, but we're not here as a World Bank to walk away, but commercial finance will. commercial finance will not engage where there's a high social risk if they're not seeing a very, very quick solution, not a long-term mitigation strategy like we work on, but a very, very quick solution. Otherwise, they'll be hammered by the NGO or the CSO community for investing in companies which are supporting labor abuses. You know, it gets flipped against you. Nestle had lots of challenges in cocoa, and 4 or 5 years ago, they did the best thing. They linked up with the Fair Labor Association to do due diligence on their website so that they could improve the system. But the CSO community said when FLA did their report, and the report obviously showed there was child labor in cocoa, Nestle was hammered for supporting child labor, not praised for identifying and transparently bringing the problem to the sector and driving and you know, developing relationships with their suppliers, developing relationship with governments, with the World Cocoa Foundation, etc. So companies are in a very, very hard space as well. But these products have to come forward. But just to finalize on my answer to you, the most important thing that's happening at the moment, and we're working on this, you know, with the European Union, we're working in countries, the European Union legislation, which is really trying to stop the importation of commodities tagged with child labor or labor abuses coming into the European Union, is phenomenal, because now governments are coming to the World Bank and saying, help us change, help us build capacity, help us find out where the problems are. So you know, the whole global awareness and what you're doing, you know, within the, you know, the developed worlds on these contracts is vitally important, because change is coming from the markets as much as it is from regulation, you know, and I think that's an important thing to identify. Anyway, that's my view. So I'll stop there. I'm not sure, Steve, if you've got any comments there. Yeah, you muted.
Sorry.
Yeah.
I did the Zoom mute. Just very briefly, and I'll sort of look at it from a very different direction, is that, you know, when I was at Root, we had a portfolio of loans in the DRC, and we had a portfolio in Nicaragua. Hard to imagine two riskier countries, right? Our default rate was 0. At least when I left it was. But you can do it. We underwrote good loans to good borrowers. Very different from the types of loans I was underwriting at Bank of America. Different quality financial, like, but what we were committed to was understanding how to do this in a sustainable way, meaning that our loans would be repaid. We also determined in both jurisdictions what level of subsidy we needed from a blended capital perspective, because the loans in the DRC were very, very small. They were, you know, probably on average $250,000, but we had benefactors who were willing to help pay the cost once we figured out how low we could go. So what made both of these portfolios successful was that we understood the value chain. We understood the farming. We understood the off-takers, importantly, the off-takers. We didn't have guarantees, but we knew who they were selling, who our clients were selling to, and we were able to follow the goods every step of the way, like you would as a banker if you were making a $20 million loan to Cargill or a $50 million loan to Glencore. Like it's using the same approach, but understanding very specifically what the risks are, how to do it, what type of legal documentation. And so it as opposed to thinking of it as a, well, if we get our money back, that's great. If not, we'll look at it as a grant. But, you know, like if we were determined that these would be good loans and be done on commercial basis.
Thank you. Thank you very much. I think we have to stop now, even if there will be certainly other questions. And Priscilla, maybe you can tell us what is happening now. We might have a short break and or go directly to the last panel. Thank you. I forgot, of course, to thank wholeheartedly the speakers for their interventions and also for their time that they devoted in answering questions. And we are very grateful for your participation. Thank you very much.
Thank you, Anna, and thank you all. Thank you to all the speakers. It has been a very interesting session indeed. The next session is session 6 in the agenda, is for us to discuss about the next steps towards the delineation of the scope of this project. So we have been addressing some topics during the interventions and the 2 previous sessions today, but we would like to organize a session with a roundtable with the chairs of the previous sessions and also the experts that are available to remain.
Right, so I know it's been hardly 5 minutes, and we apologize for that. But because the discussion was so interesting and there were many speakers, we have had to go beyond the time. And we understand there are people in different parts of the world, so we don't want to prolong this more than is necessary. This last session, if we can call it that, it really is about wrapping up and getting some high-level conclusions. What will be agreed now is not written on stone. We will, of course, we have the recording, we will be going over all the discussions, and we will try to be more precise as to what has been expressed here and decided, if we can say that something has been decided. I should stress to those of you who don't know that this is an initial, this is the inception of a mid-term project. This is the 3rd project between IFAD, FAO, and UNIDROIT, and it is it's been going on in a preparatory stage for a while. We got a mandate from our governing council to define more precisely the scope of this project, and hence this workshop and all the preparation that has gone into it. So this is just the beginning. The purpose of this webinar is to draw some initial conclusions that can lead us to drafting a document which can be approved, and then after that, as I'll explain later, a proper project with working group implication will commence. This is the beginning and not at the end, and so we are now summarizing the beginning. The way we're going to do this now is I'm going to give the floor to the chairs of the different panels, and I'm going to ask them to very briefly summarize what they would think are the key elements and any conclusion that they think that has been reached in the discussion of their panels, so we here at the Secretariat can continue doing the work leading to the Governing Council. If I may, before I do that, I would like to say that it is apparent to me that a clear need emerges moving forward, and it is that we cannot do a project, at least not a project which is valid and useful, which is merely an analysis of the law and purely based on qualitative reflections. We need data, and data which is hard data or soft data, as you will. But this is going to be one of the big challenges of this project. We need to make sure that we reach out to the different networks. Unfortunately, our networks in UNIDROIT are Rome and Central Rome, basically. But the network of FAO and IFAD is massive precisely in those countries where this guide could be most useful. So, of course, the World Bank and other organizations could also assist in the gathering of the data. But this is something we will for sure need to work on and so the working group, when the time comes, can base its deliberations and its conclusions on existing data. Having said that, let's move on to the summary of the first session, which was chaired by Teemu Vinikainen, Finnish name, no doubt, and apologies
Yes,
for apologies for my horrible pronunciation. This was a particular panel because it was to know what's out there, right, and what the trends were. And if I'm not mistaken, Teemu and Buva Bojang will both share the responsibility of summarizing this. So I will hand it over to you, Teemu, and then Buva. Once he finishes, you take over. No need to pass back to me. Thank you.
Thank you, Mr. Secretary General. The way we have divided the work is that I will be talking as the moderator for the summary conclusions from the session 1. And once we move to the overall objectives for the whole project, I will pass it on to my colleague, Buva Bojang, a legal officer working at FAO in the Development Law Service. So the session 1, as its intended purpose was, aimed to summarize some of the current constraints, opportunities, and specific needs of agriculture, small producers, and micro and small medium-sized enterprises that affect the choice that they actually have in choosing what kind of legal structure they want to use in their operations. What became clear from the discussions, from my perspective, is that the, let's call, decision space of the producers and other participants in the early stages of the food supply chain is inherently linked to a number of key aspects, such as the economic features of the commodities, the new technologies that are changing the landscape, as well as regulatory demands from the public sector, as well as from private standards. A key finding from many of the FAO speakers, not just in session 1, but in all other sessions, is the need to adopt a food systems perspective. While we recognize that the perspective of value chains, whether local, regional, or global, remains important to better align the work with the developmental directions of the in the developmental organizations, a food systems perspective might provide new entry points and new viewpoints through which to analyze the difficult legal questions that have arisen from these 2 days of discussions. This does not mean that we should ignore global value chains, and we had very interesting discussions in the session related to the governance methodologies of these both global, local, and regional value chains. And I would consider it to be of crucial importance that going forward we have a very solid understanding of the different governance methods, whether they are trader-driven, buyer-driven, or hybrid, as Jennifer was discussing in her presentation. The connection to the legal structures is quite clear, because I think it was shown in our panel that the choice of governance and the governance logic trickles down all the way to the producer level and the SME level, and it affects the way they can choose which legal structure to use. Another finding that came out that was also reinforced in other sessions is that these value chains do not operate in a legal vacuum, and we need to be aware of the legal framework that frames them. And it became clear through the discussions, particularly in the presentation from Tomislav, that the amount of regulation directed at supply chains is increasing, and this has a direct impact on the kind of work we are doing. So even if we don't necessarily want to dig too deep into that, I believe it would be important to be able to establish the legal framework that governs not just the individual legal structures, but the supply chains in general, so that we can understand holistically the context within which we are to operate. The last 2 points I want to make are related first to Eric's and then to Cornelia's presentation. Eric talked about blockchain and other disruptive digital technologies that in a very short period of time can fundamentally change the way either producers or MSMEs can do business. A lot of these, such as blockchain applications like smart contracts, have legal uncertainties in them, but they are already being used, and they provide similar kinds of benefits that we expect to see coming from more traditional legal structures, whether they be corporate ones or traditional contractual ones. Therefore, there could be scope within the project to understand this quote-unquote competition from the technological solutions to the more legal solutions. That is the primary scope, as I've understood, for the project. And finally, referring back to Cornelia's presentation, she talked a lot about food safety and how food safety principles are topics that are non-negotiable and need to be always kept in mind when we are trying to talk about any kind of intervention in the agri-food chain, so that what we end up proposing doesn't inadvertently end up lowering the food safety standards. And she made the excellent point that these do not have to be barriers for these smaller producers and SMEs to participate. They do have the knowledge and they're willing to follow the food safety standards as long as they are clearly communicated down to them. Therefore, to put this on more general terms, there may be some scope for clearly establishing the benefits of legal structures, such as the introduction of food safety standards all the way to producer level in developing countries, which otherwise may have difficulty in enforcing these standards across the agricultural field. So these are the main findings, as well as the connections I see going forward in the project. If now is the opportune time, I would pass to Buba, but if we are coming back for the overall objectives at the end of the summaries, we may wait until then as well. It's up to you, Mr. Secretary General.
No, I think it's better if Buba now finishes the view from FAO.
Thank you very much. In that case, Buba, please, over to you for the overall objectives FAO sees, as well as some of the key legal areas that we consider in general.
Yeah, thank you so much, Timo. And I wish to take this opportunity to thank the panelists and all those who have contributed. I think we are in a better place today than when we started. I think we can see some routes now. We can see at least a light at the end of the tunnel, and think we are in a better direction today. So thank you to all of you. My take today is just to look at the overall objective from FAO's perspective. And broadly speaking, there are just two objectives, and then there are some legal issues that I implore us to consider taking this argument further. And first of the legal of the objectives is to consider how small holder farmers form themselves into agricultural enterprises, and most importantly, or connected to these enterprises, is to determine what legal structure these enterprises should take. And this is important because we have what is called the missing link. And it's so important, especially with regards to the food chain supply, to the food supply chain, that the small registered farmers who are at the domestic level are also taken into account when we consider what legal structures and what forms of enterprises we're talking about. And also important to this one is the issue of gender. We need to also consider the gender lens with regards to these small holder farmers, and also to ensure that it contributes to the SDG agenda. Now, with regards to the legal issues that should be considered from our perspective, is first to determine what legal structure is most beneficial to integrate the smallholder producers to these food value chains. Of course, there we have to take into consideration the integration of domestic and regional markets, not just the global chain, but domestic and regional markets should also be taken into consideration in determining the legal structure. And the other legal issue that is worth considering is to determine what legal guidance are we going to provide if a farmer, for example, chooses a particular legal structure. What guidance can we offer to those farmers? And this is something that we need to determine. Of course, whatever guidance we provide, that guidance must be inclusive, must be very inclusive, including, of course, the gender equity aspect of it. And lastly, how do the contractual practices discuss? Because we see today and yesterday, we had a lot of contractual practices that were discussed. But the issue to determine legally is how do they affect the choice of a legal structure. So these are the legal issues that we've determined, and we will really implore this project to consider these legal issues. Over to you, and thank you so much, Secretary General.
Thank you very much. This is very, very useful. I think it seems clear that global value chain is important, but mostly we will need to focus on domestic and regional value chain, which is something which it makes a lot of sense, of course. So before I give the floor to the chair of the second session, and since this is a tripartite project, although they are not chairs of a project of a session, I would like to ask if perhaps Andres Uribe or Dagmawi from IFAD would like to add anything to what's been said already. We are extremely happy to count also on IFAD and IFAD's excellent legal analysis capacity, but also IFAD's practice on the ground from their economists and their people in the different countries, which can really make a difference, just like with FAO. So I don't know, Andres, if you want to say something, or Dagmawi, please feel free. Yeah.
Yes, thank you, Mr. Secretary General. Well, first of all, I would like to thank, on behalf of IFAD, all the experts. I think that this has been an enriching exercise that has shown us the enormous scope of this exercise, because I think that the various topics that were touched upon during these 2 days just give us this it's going to be a gigantic project, one that we are very happy to be part of, but also we see it as a huge challenge. And not to repeat what our colleagues at FAO mentioned as their objectives, because I think we share them, I would like to say something that goes more in a pragmatic sense. And it is how we will create this instrument that will provide the relevant tools to allow development objectives and the SDGs come to let's call it the final user. How will this become something usable? Not a very, not a report or a guideline that people are not able to incorporate in their own, daily lives as part of agricultural enterprises. The second thing that I think was a very interesting point, and it is how we are going to use private law to incentivize business, mitigate risks, how to bring down entry barriers and avoid bottlenecks from a legal perspective. And I think that from the work that UNIDROIT has sponsored and has done throughout the years, their experience is there. So I think that great legal minds like the ones you guys have will be able to provide with these, will provide us with these tools that will allow us to come and to bring this knowledge down to those final users that most need it. And finally, also on the pragmatic side is a special invitation to make the best efforts to be able to disseminate these instruments so they can reach an audience as large as possible. And in that sense, IFAD is at its entire availability to disseminate these instruments throughout our country offices and share it with the relevant governments and clients that we have outside of in the different countries, member countries. So on that line, I would like to thank you all again for this very enriching, enlightening. There were certain things I had no idea of, and it was absolutely a delight to participate in these sessions throughout these 2 days. So thank you, Mr. Secretary General, and thank you to Carlo and Priscilla and to the UNIDROIT team for setting this up.
Muchas gracias, Andres. Thanks very much. So indeed, FAO and IFAD will be key not only in the inception and in the analysis, but also in the dissemination. So it's a long project, but it's going to be very fruitful, I'm sure. So let's move on to the second panel, and Mr. Carlo Di Nicola has the floor.
Thank you very much, Mr. Secretary General. Thank you. So let's just move on here and just present some summary conclusions from the second session, which was yesterday afternoon. The second session focused on the contractual structures for collaboration and integration of agricultural enterprises. So just in terms of the overarching objective in that came from the interventions on that panel, really the legal guide that we're looking to develop, it should aim to facilitate smallholder commercialization of key food value chains, especially in developing inclusive chains. So we're making sure that in moving from subsistence to or an informal production patterns toward more formal market linkages with established agro-processors and buyers and off-takers, that's done. So it's done in an inclusive fashion where we're bringing on board those smallholders. We had two excellent presentations from Ms. Karina Fernandez Stark and as well as Mr. Amer Kawash from World Food Program, and they gave presentations focusing in particular on the kinds of challenges, the kinds of barriers that smallholders face when they're looking to participate in value chains. Notably, access to critical resources such as inputs, know-how, technology, access to finance is key, access to markets, as well as other things like implementation of regulatory standards, whether it's safety, sustainability, the quality of processes, and also a key point that they raised was a lack of coordination, both horizontally and vertically, which is something that is a barrier in terms of accessing global markets, but also limited coordination between producers, which then leads to poor negotiation positions relative to where they are in the supply chain. We then had another presentation from Professor Kapagi, and he raised a number of points specifically tying to the choice of legal forms. So the kinds of legal forms that agricultural enterprises use to set up their activities, well, obviously that can affect the ability to pursue the different objectives in terms of their development. For example, looking at access to finance, that may be facilitated for those legal entities which are established in multi-party contracts. That may be easier for them than it is for parties that are rather in bilateral contracts. Also, the choice of legal forms in this particular instance, it's aimed at inducing and reinforcing cooperation among micro, small, and medium agricultural enterprises. And then another point, another key takeaway is looking at the analysis of bilateral versus multilateral contracts. In this case, bilaterally connected contracts can increase transaction costs, but also provide flexibility, whereas multi-party contracts do increase cooperation. They can reduce transaction costs, but they obviously, there is an attendant increase in the governance costs. We had another excellent presentation from Professor Lorenzo Cotula, and he was looking at the role of small-scale rural producers and agricultural value chain contracts. And he noted the importance to recognize the role of the contracts in the different kinds or the different types of agricultural value chains. So whether they're local, regional, or global. And he emphasized how these different contracts are interrelated, and in particular, how the features of these different contracts affect the smallholder's voice in contracting, their voice, their bargaining power, their position, and also what the available options to them are. And then finally, he underscored again that it's crucial to acknowledge that there are many challenges involved in efforts to promote more inclusiveness in value chain relations. Also, we had another presentation, excellent presentation from Carmen Bullon from FAO, from the Legal Development Office, and she talked about the importance of having an enabling regulatory environment. And that is because the contractual modalities and the contractual relationships, they have to exist in a larger context of a regulatory framework. In terms of the legal framework, she noted there were a number of key roles played by the legal framework. One is to address power imbalance and unfair practices. Another is to increase legal security and certainty through access to dispute resolution mechanisms. And another still is allowing for better regulation through increased transparency. She also noted that there are a very broad range of legal areas relevant for food supply chain contracts. One of them is, of course, general contract laws, which is the primary focus of this project, and that also obviously the framework in question depends very much on what kind of contract in the supply chain we were looking at. So whether that's a sales contract, a service contract, insurance contract, crop warehouse receipts, financial contracts, etc. So there's a whole constellation of different kinds of contracts, even within the contract law sphere, that we will be needing to consider and look at in greater detail. And then finally, coming back again to the presentation given by Professor Cafaggi, a key takeaway is to note that the choice of adequate legal forms can contribute to increase the efficiency of agricultural enterprises by increasing the smallholders' collaboration, whether that's through the creation of cooperatives and or contractual networks amongst the actors. So just the final point here is a critical one again. The project will need to examine how the use of those collaborative contracts in the agri-food supply chains can specifically help in addressing a number of those barriers that we had mentioned just at the beginning of this summary session. So again, just to recap, that's things like improving access to market, identifying the optimal legal structures to do so, increasing the size of agricultural enterprises, and again, the role of contractual and company networks, whether directly or through collaboration within and across agricultural commodities, how that can help increase the size, therefore improving access to market. And then another one, two more points. One is easing access to critical resources, including the question of insurance. That's a key question in the agricultural production and supply chain. And then finally, addressing the importance of addressing unfair commercial practices. So that is the summary of just the very broad, big points summary for the second session. And I'm happy to I don't know if there are questions, but I'm happy to pass it back to the chair and we can move
Thank you,
on.
Carlo.
Thank you very much.
Just with these, we could just form a project just with what you've explained. So thanks for this comprehensive and very clear summary. Now we move on to panel 3. Panel 3 was chaired by Professor Fabrizio Cafaggi. Fabrizio Cafaggi, I think, is the right time that I make it clear to everyone here, has been absolutely instrumental to the preparation of this exploratory workshop, has been helping us to the most important details and also providing us with an overview and a legal picture, which only he has, because he is one of the world leading experts on this front, on this branch of the law. So we are extremely grateful to his input already, and we very much look forward to the much more input he's going to have to give us in the coming years. Fabrizio, with that, I will ask you only to speak about your panel. Thank you.
So thank you very much for your kind words. It's been a pleasure to working with you and the team. So I want to be very brief to let the other panels speak broadly about what they said. So the first point is that there is a connection between the remedies, especially remedies for breach of contract, but also in case of unforeseen contingencies and force majeure, and the type of dispute resolution mechanisms in place. A distinction was made by several contributors between formal and informal dispute resolution mechanisms, and especially Matthew Janijon underlined the connection between the procedural dimension of dispute resolution and the substantive content of sanctions by distinguishing between reputational and non-reputational sanctions. The second point is basically that when we look at remedies, we have to keep in mind, especially given that 80% of the trade occurs within supply chains, that stability of the chain means stability of the flow of goods and services is very important. And so the main aim of remedies is to induce cooperation before and after the breach, rather than being disruptive and terminate the relationship. The third element, which was developed primarily by Carlo Russo, is that within chains we have an even distribution of contractual power, which might result into abuse of power, unfair commercial trade practices, against which remedies are provided by legislation. And again, I think there is a link between fairness and unfairness of the relationships within the chain and the ways in which legal forms operate and remedies for breach operate. So we need to incorporate, and this is something new compared to what we did for the contract farming legal guide. We need to incorporate the fairness and unfairness dimension of contractual power into the picture. The fourth element, which links up with what Carmen and others said in the second session, is related to the fact that there is a clear integration between the private law dimension of contracts and the regulatory dimension concerning safety, sustainability, and quality. Private law and contracts are implementing transnational standards, but also national standards by way of obligations concerning process, not only products. And this has an influence over remedies. So when we consider remedies for breach of contract, as Paola Iannicelli said, we need to look not only at remedies for product requirement, but also remedies for process requirements. Point is related to the distinction between remedies in bilateral contracts and remedies in multi-party contracts. There are distinctions, and again, as in relation to the guide, the contract farming guide that focused primarily on bilateral contract, multi-party contracts play a major role, and so we need to distinguish between the set of remedies that are available in case of bilateral contracts vis-a-vis multi-party contracts. The final point is related to the issue of intermediaries along the chain and the role they play in favoring dispute resolution, basically mitigating or resolving conflicts. Axel Marx talked about the voluntary standards in the field of sustainability, giving us examples on how these intermediaries might play a role in mitigating these conflicts. And it is very important to understand that courts in this particular field play a relatively small role, and dispute resolutions are primarily run and carried by informal systems. And when it is run by formal system, it tends to be arbitration or other type of ADR rather than courts. And this again has an influence on both the type of available remedies, the cost of access to justice, and its effectiveness. Thank you.
Lovely. Thanks a lot, Fabrizio. Okay, so we move on to the fourth panel now, and the session chaired by Priscilla. Priscilla, over to you.
Thank you, Ignacio. Thank you, everyone that is still here with us. So I have the task of summarizing session 4, which dealt with corporate structures for the organization of farmers and agricultural enterprises. During this session, this fourth session of the consultation webinar, we mapped different legal entities that may be used for the organization of these farmers and these enterprises. The 6 presentations that we heard today, this afternoon, highlighted the importance of choosing an optimal legal structure for better coordination, inclusiveness, and access to market and finance. It was emphasized that the different points in the value chain may require the establishment of different legal entities, which may vary from cooperatives, corporations, special purpose entities, limited liability organizations, joint venture agreements, agricultural condominiums, and producer companies. All the presentations make us conclude that the reality changes depending on the jurisdiction, type of activity, the size of the enterprises, and also the degree of homogeneity of the members, and also the degree of integration itself between the different stakeholders. So based on this fourth session, and I'll keep it brief, the key takeaways from session 4 for the legal structure of agricultural enterprise project may be to further consider analyzing the effects of integration, both operationally and organizationally. So it may be important for us to further consider the impact of integration, not only in terms of the legal structure, but also in terms of the application of traditional, for example, cooperative principles, especially the principle of autonomy and democratic member control. The project may also consider analyzing the challenges of identifying the applicable law in the global value chain. Moreover, the project can deal with the dissipation of financial and other responsibilities throughout the value chain. And it was also interesting to hear the need to address the risk of demutualization, the challenges regarding ownership, and challenges regarding the possibility of dissociation of assets and capital in the context of indivisible reserve, for example. Making it short, the project could look into the relationship established by the different stakeholders of the global value chain in both the contracts and the corporate structures. So it could analyze both these together, and it could further analyze one of the concepts that was brought by one of the presentation, which is the contract organizational law. And to briefly conclude, I think the fourth session confirmed the interest and the need to further analyze these challenges identified and the need to identify good practices of legal structures that may lead to more formalization, integration, and inclusiveness. So those are my brief remarks. Thank you, Ignacio. Pass it to you. Thank you.
Thanks a lot, Priscilla. I really appreciate especially you coming up with such detailed account in such brief period of time. That was very good. Thanks a lot. We move on to our fifth and last panel. Karana, the floor is yours.
Thank you very much. I'll be brief. As you know, the fifth session focused on access to finance, and I think the main point that was made not only in this panel but also in other panels was that a legal guide should consider access to financial resources as one of the main objectives when providing guidance on the organizational or contractual infrastructure of agribusinesses. We have heard from some of the speakers in this panel that the legal structure of the enterprise does impact on access to finance, and particularly inclusive access to finance in different ways. One of the ways is when we look at the structure of the agribusiness itself. which is seen in certain situations as a precondition to evaluate credit worthiness. And so the importance of providing a sufficiently simplified but formal structure for agri-enterprises was underlined. And in this respect, the fact that other organizations have international intergovernmental organizations have worked or are working on this was also underlined, and the need of coordination in this respect. So, for example, the OSAS and UNCITRAL. All speakers focused on the challenges and barriers, particularly for SMEs, in using the more traditional financing methods, for example, bank loans. But it was interesting to hear that there are challenges even when using methods that are considered particularly suitable and suited to SMEs, like, for example, warehouse receipts. So a legal guide probably also look at all these different types of financing and see whether the legal structure or the contractual relationship between the enterprises may have an impact on that. The other impact of the legal structure is on the financial vehicles themselves and their relationship with the enterprise needing credit and the entire value chain. This was underlined by bringing specific examples in certain jurisdictions. I think in the end, what resulted out of the discussion was the need to look at alternatives in order to go beyond traditional schemes, but also to capitalize on existing good practices, and so to conduct empirical studies, more empirical studies. And the alternatives might actually help reaching additional policy goals, such as, for example, the Sustainable Development Goals, the food safety, environmental protection goals that were highlighted, especially in the first panel. And so this link was quite interesting. The second element was that alternatives will probably focus on innovation and the use of technology. And the third point was the role of contracts. That was not the only panel underlined this, the role of contracts along the value chain in shaping the relationship with financing entities, or more generally in facilitating access to credit. So I think I may stop here, and we hope to hear also more from the other experts in the future. Thank you.
Thanks a lot, Anna. So indeed, how business structures are designed and how that is going to influence access to credit needs to be an important part, at least needs to be considered in the project. That is an important conclusion. I would, if you allow me, I will include two items which have not been mentioned by any of the chairs, at least not directly. They have in part, and they come from my own notes, but stem from ideas that I've heard from the speakers. One of them is, I'd like to reinforce the importance of the technology element, and I believe throughout the project, how technology influences the value chain and generally the structure of the legal entrepreneurship of the agro-business is going to be key. So we need to keep an eye and make sure that that is considered throughout the project. And the second one, more particular, was, I believe, mentioned in passing by Professor Hansen, but which was Hagen, sorry, extremely important, I believe, is we might need to include an element of applicable law, especially when we are considering a value chain which is beyond domestic and goes into a regional dimension or even global. What law applies to some of the different elements of the chain would seem to me to be an important element which I can't overlook. So that might be something we need to feed into the discussion, perhaps, if the experts so decide. So thanks so much for this incredible effort. It only remains for me to wrap up and explain simply that in the coming weeks, we will be preparing together with FAO and IFAD and perhaps a few of the experts, the document to be presented to our Governing Council. The document will need to be ready by end of August, so that decision can be adopted in September. We will, of course, be coordinating this with FAO and IFAD, as I said. In this process, this exploratory time and this preparatory work, we count on the help of Professor Cafaggi again, and also of Professor and Justice Lorenzetti. It might be good for all of you to know that UNIDROIT projects need to be chaired by a member of the Governing Council. That is what happens with our projects. And the opening of this webinar hybrid yesterday was done by Ricardo Lorenzetti, who is Justice at the Supreme Court of Argentina and one of the world's experts also on the topic. And Ricardo will, if he continues to agree to it, be the chair of the working group that will be formed after the Governing Council. And that will be a huge boost to the project, and we are extremely grateful for what he's done and especially for what he will do in the future. So it only remains for me to thank all of you and make a special reference to the UNIDROIT team, if you will allow me and indulge me, the work done by all of them, those who've participated here, but also others in the background whom you haven't seen, Valentina Viganov, François Guin, and others from the team. I need to express reference to Gabriela Prado, who's also been extremely useful and has followed the preparations all throughout. And finally, of course, the biggest thanks go to Priscilla, with whom you've all been liaising in these months, who is the legal officer that's going to be leading the project from our standpoint, from our side. Thank you, Priscilla. Thank you, team. Thank you all. And we'll be seeing a lot of one another in the coming months. Thank you. Have a good weekend.
Thank you very much. Bye-bye.
Thank you, everyone. Have a good weekend.
Bye.
Thank you.